Good morning, everybody. Happy Super Friday. Welcome to TCF Live. I'm Dan Soul. I will guide you on this 3-hour journey through Courtlandia. We start in Royal Oak, Michigan. This is the Magistrate Court.
We can. Some rules of procedure today is that criminal cases trump civil infractions. So if I have a criminal case that is ready, I have to take that before I take the civil infraction case. Counsel, is it Attorney Bigler? Good morning.
Good morning.
Is Ziegler here? Is there a Ziegler? Is Ziegler? I don't see a Ziegler yet. Okay. Harris, Tyrone Harris, where are you, sir? All right, I'm going to put Mr. Harris and Miss Bigler. Where are my breakout rooms?
Your Honor, I've already spoken to Mr. Harris.
Oh, well, that will work wonders.
Might be able to help out this morning with that.
I'm sorry, could you repeat what you said kindly?
I've spoken to a number of these people.
Oh, that's so great.
It might be able to help us. Okay.
Yeah, we have a big docket.
Yes.
Okay. So as soon as I'm done with this gentleman's case, it's Mr. Harris, right? Then I'm going to go to my 8:30 civil infractions. Now, I'm looking at the docket on the civil infractions. If you have things with no registration, expired plates, obstructing the rear, anything like that, if you've taken corrective action, such as you got insurance or renewed your tabs, make sure you have that documentation with you when your case is called. Okay, let's call Mr. Harris's case. Are you ready, Madam Clerk? Calling the case number of 26RO0, strike that, 26R01008. This is the City of Royal Oak versus Tyrone Harris. Your appearances, please.
Good morning, Your Honor. Joanne Bigler, appearing for purposes of arraignment for Mr. Harris. Mr. Harris, could you state your name for the record?
Tyrone Harris.
Good morning, sir.
And
Good morning.
thank you. We consent to appear by Zoom. Your Honor, Mr. Harris, my understanding is charged with domestic violence, and he is standing mute to the charge.
Okay. And with respect to the reading, are you waiving formal reading or would you like a reading?
We'll waive it. That's the only charge. Am I correct?
1 second, please.
Sure.
Yes, ma'am.
Okay. Yes, we will waive the reading then.
Okay. So we'll waive the formal reading. I will do so if you make a representation to the court that when you talk to your client previous to this morning that you advised him of the nature of the charges, the possible penalties, and his constitutional rights.
Mr. Harris, do you believe you understand that?
Yes.
Okay.
I'll waive the formal reading. Did you say defendant stands mute or pleads not guilty? I missed that part.
Well, plead not guilty.
Defendant pleads not guilty. A not guilty plea shall enter on his behalf. Is he requesting assigned counsel?
I did not. Are you asking for court-appointed counsel, Mr. Harris?
Yes.
Yes.
Okay. That is granted. Counsel shall be assigned for you, sir. And is McCage Street in Detroit a good address for you?
Yes.
And is your phone number end in 6359?
Yes.
Is the McKay address, did you cohabitate with the alleged victim, or is that your separate address?
Separate.
And say it again one more time, please.
Separate.
Okay. So I've confirmed the defendant's address and his phone number.
Would you like his email address?
You may.
Okay. It's TYR @48 @gmail.com.
Okay. And what do you have to say about bond and bond conditions?
Your Honor, I would ask that the court grant him a personal bond. It's my understanding that the parties have done this. They've been had a relationship, have been split up over a year ago. This is the first and only issue they've ever had. It was a phone call made by a friend, not by the mother of his child. They have been co-parenting since this event without contact and without issues.
What does that mean without contact?
They're not having contact over the parenting time.
How many children do they have together?
2 girls, a 7 and 3-year-old.
Okay, 1 second. And where do the children reside?
I did not get that address. Where do they live, Mr.
Do
Harris?
they live with their mom?
Yes, they live with their mom.
Okay. And how are you exercising your parenting time with the children? Where's Mr. Harris? I lost someone here. There you go.
Yes.
Okay, so since the date of this alleged incident, how are you seeing your children? How are you arranging that?
My mom will go pick them up. And bring.
Okay. And is that working well for you?
Yes, that works excellent.
Okay. And do you have a formal parenting time plan, or do you just have a arrangement with the mother of the children?
Just we always had the arrangement when I'm not at work that I can just call and get them whenever.
Okay. So you're doing that through your mom now?
Yes.
And the mother and you, the mother of the children and you don't cohabitate, do you?
No.
Okay. And your mother and the mother of your children, the alleged victim in this case, do they have a good relationship? They're okay talking together to exercise your parenting time?
Yes.
Okay. And who picks up the kids? Does your mom go and pick up the kids?
Yes.
Okay. Is the mother of their children and your children still residing at the 13 Mile Road address?
Yes.
Where's my phone? 1 moment, please. Okay, the court is setting a $7,500 personal bond. No money is due at this time with the following conditions. Okay, you have to, where's Mr. Harris on the Zoom? I keep losing him. Oh, there. I have so many people on my Zoom and I like to look at the person when I'm putting the bond conditions. You have to personally appear, whether that be by Zoom like you're doing today or in person if ordered by the court for any and all court events in this case. Okay, so if it has your name on it, this case number, you have to be in court whether by Zoom or in person. Do you understand that, sir?
Yes.
You have to abide by any judgment, enter in this case, and surrender to serve any sentence imposed. You are not to leave the state of Michigan without permission of the court. You are not to commit any crime while you're out on pretrial release. You shall immediately notify the court in writing should your address change from McCage Street or your phone number ending in 6359 changes. You are not to use alcohol, marijuana, or any other illegal controlled substance. You are not to possess or purchase a firearm or other dangerous weapon. You are not to harass, intimidate, beat, molest, wound, stalk, threaten, or engage in any conduct that would put the mother of your children in reasonable fear of herself. You are not to assault, harass, intimidate, beat, or wound. I have to get the mother of your children. Her legal name will be set forth in the written order from the court. You shall have no contact with that individual. And when I say no contact, sir, that means every way, shape, or form possible that you can think, okay? No text messages, no smoke signals, no messages through third parties. Tell her I said this, like nothing, okay? You have to stay away from her and not speak with her while this case is pending until further order of the court. You shall not enter upon the premises where she and her children live. The 13-mile road address will be in the order. To coordinate parenting time, that's the only, anything having to do with the children's welfare. Like if you had the children and they were sick and you need to communicate that to mom, you have to do it through your mother. If you want to see the kids, your mother has to be the go-between between you and the mother of your children. Do you understand that?
Yes.
So this order doesn't prevent you from being a dad or having your children during parenting time, but it has to be coordinated through your mother. Okay?
Yes.
And we will set this matter for a pretrial. You will have assigned counsel, and the notice to appear will be sent to the McCage address. So to recap, we held the arraignment, we waived the formal reading, defendant pled not guilty. Not guilty plea was entered on your behalf. I've confirmed your address, your phone number. Your bond is $7,500 personal. No money is due at this time. Standard court rule conditions. In addition, you can't drink. You can't have any contact with the mother of your children. You can't engage in any assaultive behavior. You can't carry a weapon, and you can't go to the house. To coordinate anything with the children, you must do so through your mother. We'll set this matter for a pretrial. The notice to appear will be sent to your Detroit address. I'm sorry. And you will have an attorney be in contact with you. Okay. So the next thing, look in the mail. Your next court appearance is going to be called a pretrial. That's with Judge K. You're going to have a different Zoom ID than you used today to log on. So please make sure that you log on to the proper courtroom at that time.
Okay.
Okay. Do you have any questions for the court or for your attorney?
No.
Okay, thank you, sir. This concludes your arraignment. You may leave the Zoom.
Thank you.
Okay, thank you. Madam Clerk.
All right, good morning once again, everybody. It is TCF Live on a Super Friday. It's good to have you all here. If you haven't yet this morning, please do take a moment to say hello in the chat. We're friendly folk here. Also, I would like to direct your attention to the pinned chat. TCF Court Watch. We launched it yesterday. It is an enhanced viewing experience for you. If you go there to watch the show, you will get the YouTube feed, you will get the YouTube chat, but you'll get a whole lot more. So do go check that out. Once you get there, the first thing you should do is read the FAQ. It explains everything, and I think you'll like it. The feedback yesterday was really good. We deliver a lot more information there than what we can just do through YouTube. So it's a good place to watch. All right, we're going to keep our eye on the Magistrate Court, but let's do this. Let's go to Lake County, Ohio. Judge O'Donnell. It's important to start our Friday morning with a healthy amount of swear words, so this is the right judge, I think.
We're here in State of Ohio versus Sedonte Smith. 26-365, motion to suppress. Counsel ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
All right, go ahead.
Thank you, Your Honor. The evidence, we'd ask you to incorporate our arguments, our briefs into our arguments, and the evidence will show that the defendant was detained lawfully. A pat down yielded a suspicious lump that the officer believed was cocaine. He was writing the defendant a written warning, which wasn't even completed when the defendant admitted that he had cocaine in his pocket. The total stop was 11 minutes and 18 seconds from the time he was detained to pulled over to the time he was arrested. We'd ask you to deny this motion. Thank you.
Mr. Deeb?
Your Honor, at the time the traffic stop was completed, a warning was issued and Mr. Smith was not informed that he was free to leave. The officer continued to question him, did not tell him that he was free to leave, and subsequently the cocaine was found after my client, after he'd asked him several times, he finally said, yes, it's cocaine at that point. But the traffic stop was completed and then it continued for that short, brief moment. It's only about 30 seconds afterwards. But we believe that the officer should have told him he was free to leave, and at that point turned it into a consensual encounter, and that would have made everything admissible. But we believe that in violation of his Fourth Amendment right, he continued to seize him at that point instead of releasing him. And therefore, the statements that were made and the drugs that were found were based on the fact that he was in custody and not free to leave. It was not Mirandized, nor was he told that he could leave, so he was still seized, Your Honor.
All right, Mr. Gegrich?
I think, Your Honor, at this time, Ms. Dibba, I would call Officer Brown from the Willoughby Police Department.
Step forward. Raise your right hand. You swear a testimony about to give is the truth, the whole truth, and nothing but the truth. So help you God. All right, have a seat.
I'll stipulate to his qualifications.
No.
Your Honor, we'd stipulate to his qualifications. The prosecutor's free to ask whatever he'd like.
All right.
Thank you, Your Honor. You state your name, spell your last name for the record, please.
Fred Brown Jr., B-R-O-W-N.
And are you employed, sir?
Yes, with the City of Willoughby.
And how long have you been with the City of Willoughby?
Since May of 2022.
And what's your duties with the Willoughby Police Department?
I'm a patrol officer.
And where are you assigned to?
Just patrol within the City of Willoughby.
Okay, and have you ever had occasions to make drug arrests?
Yes,
And how many would you say you've made?
many. Hundreds.
Have you made arrests for cocaine?
Yes,
Have you made arrests for marijuana?
yes.
And how many of these arrests were subsequent to a pat down, to where you were able to identify narcotics by plain field?
Many of them.
Okay. Were you so employed on March 14, 2026?
Yes,
And did you have an occasion to be in the area of 38257 Glen Avenue in the city of Willoughby, Lake County, Ohio?
yes,
And that's the sole parking lot, is that correct?
yes.
And why were you there?
I had a black Nissan sedan pass me when I was at 2nd and Erie. I checked the registration using leads and learned it was expired on February 20th.
All right, so it doesn't have a valid registration for the vehicle,
No.
right?
Correct.
And you affected traffic stop.
Yes.
And how many people were in the vehicle? Tell us about that traffic stop.
As the vehicle pulled into the Seoul parking lot, I initiated a traffic stop by activating my overhead lights. The vehicle then continued to pull to the back of the parking lot and parked behind Barrio.
And did you notice anything suspicious about the individual inside the vehicle?
While it was coming to a stop, the driver was moving around his immediate area, vicinity inside the vehicle.
And did you know who was driving the vehicle?
At the time, I did not, but as soon as I approached the vehicle, I immediately recognized Donta Smith.
And how'd you recognize the defendant? Or before you do that, can you know Dante Smith, is that correct?
Yes.
Do you see him in the courtroom today?
Yes.
Can you point to him and tell me what he's wearing?
He's wearing a black jail.
We can stipulate to identify my client, Your Honor.
All right.
And how do you know him?
I know him from working the bar details downtown, working 1899 Valentine, the Yard. I've had numerous conversations with Donta. I've had him on prior traffic stops where a driver was found with drug paraphernalia. And then we also had a case with Donta at the garage bar within the last 2 years or so where he was arrested for cocaine.
And so throughout those interactions, you've had an occasion to be able to assess his demeanor.
Yes.
Okay. And how would you characterize your encounters with the defendant?
Usually when I speak with Donta, he's laughing, joking with me. He's usually pretty upbeat and happy.
Was that the case? Was that the demeanor he showed you on March 14, 2026?
No, he was very withdrawn and short in the conversation that I was having with him over a minor traffic stop for expired plates.
How would you characterize his demeanor that day?
Withdrawn. He just seemed like he wanted me to go away. He did not want me to continue to be by him.
You noted that he was acting extremely nervous and pacing outside of the vehicle. Is that
Yes.
a fair characterization?
Yes.
Now, you were in a marked Willoughby vehicle
Yes.
with lights, sirens, the whole 9 yards?
Yes.
And was it equipped with a dash cam?
Correct.
Okay. You play that? Just the first couple of things, I'll have them. And it was working that night?
Yes.
Which
Stream one. And is that your dash cam that night?
Yes.
And where are you sitting currently?
Right outside of Malarkey's at 2nd and Erie.
And is that a fair and accurate depiction of what you observed on March 14, 2026?
It is.
And tell us what you were seeing as it...
As the vehicle came to a stop at the stop bar there, I checked the registration of the vehicle, and then I learned that it was expired.
And that's the parking lot itself?
Yes. You guys go around. Unlock it. What up, Tate?
Do this time.
Your plate's expired.
Oh, this what? Really?
Yeah.
Damn, it's Nick shit. I didn't even know. Damn, this my nigga shit though. This
Okay.
Nick stuff. Oh yeah, his birthday. What day?
February 20th.
That's when it expired.
Yeah.
Oh, I didn't know. Damn.
Well,
Damn.
you valid and everything?
Yeah, I'm valid.
You got valid driver's license?
Yeah, I got insurance.
You do?
Damn. I'm about to call him. What the fuck?
You got insurance on you?
Yeah, I gotta show you.
You're valid. I'm gonna get you out here with the
I'm
warrant.
about to show you. I got it on my phone. Damn, man, where the fuck you been at?
Just doing my stuff, doing my normal shit.
Hold on, I got it. About to show you my
19 radio deal.
and I'm gonna call him.
Sam David 185-847. Is this a bag of ketchup? Can I pull it out and check it? Bag of garbage.
Good.
I ain't seen you in a minute. I actually worked down here like a week
Man,
ago.
I've been tired, man. My daughter all sick and shit. Everything.
You got kids? Oh yeah, you got kids.
Man, why you ain't tell me the tags expired?
What's up?
Your tags is expired. Your tags, your car tags.
I'll be off night.
Yes, sir. What you mean? Oh. Hold on.
Tell you what's the phone number for you?
216-541.
216
541.
541.
9716. I'm trying to find my insurance. Really.
Anything in the car should be worried about?
No, sir.
No.
Got it? No.
No? Mind if I check?
Yes, sir. Let me get out. Let me, you don't need my insurance?
No weapons on you?
No, sir.
Mind if I check? Can I check inside your pockets?
Okay. For what?
Just asking. Yes or no?
I mean, what, am I under arrest?
No, just checking.
No, sir. No.
No? I'm going to check for weapons, okay?
Okay. What you got to go in my pocket?
I'm not.
No?
Hey,
Okay.
hey, I just asked. I just asked. What would be in this pocket, Tay? What's in this pocket here?
Man, I'm under arrest or no?
No.
Nothing, man. I just got out the car, let you in and
So
everything.
is that when you noticed
All right, so nothing in the
Hold on.
Nothing, man. Damn, this car.
Stop there.
Last time I did this shit.
I apologize.
Sorry.
Is that when you noticed what you believed was powder in his pocket?
Yes.
And was it large, small?
It was a large lump of a powdery substance.
Okay, and in your training and experience, what did you believe it to be?
Cocaine.
All right, please continue.
I want you behind him when he's that's all.
Hey, Tay. You know me.
You always giving me hell. It's nothing.
When have I given you hell?
Nothing in there.
When have I given you hell?
I didn't shit, man.
So there's a reason why I'm doing this. When I pull you over, you're moving around a lot.
No, because you asked me
So I'm just asking. Just asking. You gave me consent to search your car. If you don't want me to search your car, tell me no, I won't.
I mean, it's not my car.
So yes or no?
What you want me to do? I mean,
You said
I don't know
yes.
what the right thing to say.
I ain't even checked it. Because I feel like you're telling me no.
Mr. Brown?
Nothing
You know I ain't fucking around, man. But I'm mad really because I'm in the car. Man, dang.
I told you I'm probably going to give you a warning.
You said you want to give me the ticket.
When did I say ticket one time to stop, Tay?
Go ahead, big dog. Why you ain't tell me these tags fucked up?
I'm not even checking. I told you I wasn't. Just hang on right there. No, we're good. No, I'm already going with it, so no, it's fine. No, we're all good. No, Tay, we're gonna be cool after this. It's fine.
I'm mad. I don't know if you want to hold it or nothing. You know, I don't know because the tag expired.
How bad did they expire?
By like 2 months.
2 months? Oh.
You hear this shit, man?
Hey, listen. No, hey, real quick. If I wouldn't even notice it was you when you were next to me, I wouldn't even stop you.
Because now I got to get home. I got to leave. You got to get up here and get the car.
I didn't say I'm towing it. You're going to be allowed to drive it home, brother. When have you had it?
No.
How many times have you had an interaction with me?
Yeah, but you know I don't like to be. That's if it happened again. Shit.
Where are you going to?
No, I got to go.
Taking the car to?
Not bad if I get the freeway.
Freeway?
Watch out for the troopers.
Yeah.
All right, y'all. Excuse.
Get on at Lost Nation and Revine Street here. It ain't going to another city.
Mr. Brown, man. I'm sorry.
Freeway, don't do one.
Oh, you gotta check that's why I was looking for my insurance for you.
That's what I wanted. Hey, how many times have we had
I know,
interaction?
Bert. I know you. You know I fuck with you.
And you know I'm
always doing that shit.
You stop with that real quick.
Nigga I hate this type shit.
So he's indicating he's trying to show you his insurance. How's he doing that?
He's looking on his phone.
Okay,
I think he was waiting for it.
Pull it up, or
I think he had, at the time of stop, he had called the owner. I think he was trying to get the owner to send it to him. I'm not positive.
okay. So at this point, what are you doing?
I'm beginning to type the written warning for the expired plates.
All right, please continue.
And my insurance is
You ain't had a ticket since 2020.
I know I did have a ticket like really recently, bro. But I don't have a lot of tickets. My license valid, right?
Yeah.
Thank you. My license ain't valid. I remember you from the last time.
Yeah, I was from
How you doing? Hey. You gonna let me move that car out the way?
Just leave it right there for now.
You gonna take it?
No, I ain't gonna take it. I'm giving you a warning ticket and I'm getting you the hell out of here.
Okay.
So, hang on, I'm lean up against my tire here. The car's dirty.
Let you do you. Dang, man. Everybody always thinking shit going bad. Smith bringing all the trouble to the party. St. Patrick's Day.
We're off, thank God.
Y'all off.
No, we're off, thank God.
Oh,
We're near here.
Oh, she's happy.
Oh, yeah.
She's happy.
He'll be down here working. But
Did you show me proof of insurance?
Yes, sir. I can show you on my internet. Let me go to my web, my browser.
What's your phone number today?
216-541. If I get my Gmail, I can show it to you. I just paid it. Here, man. Let me call you back. Get to my Gmail. I got some insurance.
I had a little bag of weed. I had a little bag of weed in your pocket.
I got a motherfucking 20s. Weed shit.
I ain't worried about no weed. I'm not worried about a little weed.
Yeah, I don't want you to put it on front of them.
They won't care. It's legal.
No, it ain't. Not for me.
So at that point, he's telling you he has marijuana in his pocket?
Yes.
And from your experience and training and that plaint and the touch, you knew that wasn't true, is that correct?
Correct.
Please continue.
Legal for your probation. You're on probation?
Yeah.
Well, I ain't gonna be worried about a little weed.
But that's still, you see if I get caught, shit, I'll be violated.
Well, that's if I report it.
Oh. Well, I like to get high. And I know I just got piss tested, so I'm good for a couple of days. You know, let me get this insurance.
Are you on post, perchance? There's a Richard here.
Yeah, if I would have even known that was you next to me, I wouldn't even care.
I seen you. You didn't see me doing it. Damn. I got it going. There I go. Okay. Here I go. Insurance name is.
What direction?
Hold on. There I go. Did you already find it?
No, I have no way to look it up.
You have no way? Okay.
No.
What's today? Thursday? Mercury. There we go. Good. Mercury. Hi, Dante. Nope, not this.
No.
Hold on.
What do we got? Expired plates.
I got it. Okay, here I go. It's iPhone 7, so you gotta bear with me. Here I go. And this motherfucker ain't got no gas in the car. All this stupid. Fucking me up today. I'm mad. Give me a minute. I don't know who my insurance is. I guarantee you I got it. I thought when you got it on your license you can check. Oh, there it is. Here we go.
Give me 1 second.
Dang.
26.
I just paid. Just hold it when you get a chance.
Stop it for a second.
I'm freezing, man.
What's that clicking sound we're hearing?
That's me typing the information required for the written warning.
And for the traffic stop, he needs to show proof of insurance. Is that true?
True.
Please continue.
But I don't know how to pull it up for my insurance card, but you can tell that I paid it. It said, thank you for joining our coverage. Here you go.
Okay. It's just a warning ticket anyhow. It's not that big of a deal. So,
Thanks, man.
I told you.
But I'm about to move that shit. I'm not riding it back.
Hey,
Sorry.
so how long you know me?
I know, man.
And you- and-
I'm glad it was you. I'm like,
Listen, and you know, we're usually cool.
Yeah, we always cool.
And I think you have respect for me and I have respect
No, I
for you.
do. You already know if something pop up. We already had this talk. If
And
something pop
I
up,
know that. But you know what my biggest concern is down here?
Yeah, and violence. You hate it.
Violence and drugs.
You hate it.
So I'm going to go out on a limb.
Thank you.
Huh?
Thanks, bro.
No, I'm going to go out on a limb. I'm not done talking, so bear with me.
Oh, okay.
All right. I have a feeling what's in your pocket is a bag of coke. And if you want to be honest with me, it's the difference between going to jail today or not. Is a bag of coke? All right. No. Turn around. Tay, don't do all that. Tay, don't do all that. I didn't say you were going to jail.
What are you doing?
Okay, I didn't say you were going to jail.
What are you doing?
We'll sort it out.
Hey,
What are we doing? What you doing?
I wasn't going to do anything until now, but now we're going. Now we're going in the routes we can. We're gonna start resisting and stuff. It's going in a different route. Like, start lined up.
I know, stop trying to twist. Relax this arm, man, okay? Relax this arm.
Get the phone here.
I got it.
Hey, I didn't want you to do all this.
I told you I'm good.
Well, you told me you had a bag of coke in your
No, I did
pocket.
not. I got weed in my pocket. You did it. That's crazy, bro.
Alright, you're like a.
That's crazy, bro.
I wasn't trying to do all this. I was going to take it and talk to you about it and go from there. I'll fix it. It's the second one to rip on me.
This is why you got 5 kids.
That thing. Alright. Hold on.
I ain't going nowhere.
Wow. 19 radio.
Take.
And you removed the bag from his pocket at that point?
Yes.
And what was it?
It was 2 bags. What I could tell was 2 bags of white powdery substance that, through my training experience, I could immediately identify as cocaine.
And it ended up being 26 individually packed bags,
Yes.
and they were broken down into half grams, 1 gram, and 8 balls. Is that correct?
Correct.
And from the beginning of the stop to where he admits that he has cocaine in his pocket, that's approximately 11 minutes and 18 seconds. Is that correct?
Correct.
Nothing further. Thank you.
Mr. D.
Thank you, Your Honor. Up until the end, that traffic stop seemed fairly friendly, correct?
Yes.
And you testified earlier that you've had numerous experience with Sedonte.
Yes.
Most of them have been Pleasant, except for the one where he was arrested, correct?
Correct.
And on this occasion, he was well within his rights to not allow you to enter his pocket during the traffic stop. Would you agree with that?
Correct.
And while you had prior experience with him, when you felt that, and what you felt, it could have been any number of different objects, correct?
I was fairly certain it was cocaine.
And you based that based on your past experience with Dante?
Yes.
And when you felt it, you squeezed it to see that it was something soft, correct?
No, I did not.
No, you just pat it down with the side of your hand?
Hand open, flat palm,
Just
and
show us.
push straight down on it.
And it could have been a bag of weed?
No, I do not. I know it was not a bag of weed.
Okay, but you are saying you were certain it was cocaine?
A bag of a powdery substance in his pocket.
But it definitely wasn't a weapon, correct?
No, it was not a weapon.
You were 100% sure it wasn't a weapon?
No.
Okay. And then, just moving forward to the end of the video, just before you ask him to focus on that pocket, we hear the printer going, correct?
Correct.
Okay. And at that point, you would give him a citation and then ask him some questions about what's in his pocket, correct?
I was waiting for the printer to print. As it was printing, you can hear me rip the paper off the printer, and as I'm talking to Dante, I'm folding the ticket like I do on every stop.
But you don't hand him the citation, you divert to focusing on his pocket, correct?
As I'm folding the paper and I hand it to him, and I'm in the process of handing it to him, is when I...
That's when you tell him, I have an idea, that's when you have that dialogue that I think there's something in your pocket?
Correct.
So at that point, you continue the traffic stop to focus on what was in his pocket since the citation had been issued to him, correct?
It wasn't issued to him yet. I was...
You said you were handing it to him, and then you said, well, I want to talk about what's in your pocket.
Yes.
And then maybe even just 15 or so seconds later, he tells you what it is, correct?
Correct.
So at that point, when you issue him the citation, how come you didn't tell him that the traffic stop was over or that he was free to leave?
I don't do that on any stop. I usually just hand them the citation and have another 2-second conversation about what they typically do, and then we part ways.
Yeah, but at that point, once you issue them any person that you would stop, as soon as you issue them the citation, it's completed, correct?
I agreed. I mean, yes.
Yeah. And we can say in here, you continued after you issued him the citation, you continued to have a dialogue with him after that to investigate the contents of his pocket, correct?
Because of his demeanor, I had a reasonable suspicion that what was in his pocket was cocaine.
And that was just based on an open hand touch from you and your belief that he had cocaine based on a prior arrest?
Yes.
And you're saying that there was nothing else that could have been in his pocket?
I had reasonable suspicion that it was a bag of cocaine in his pocket.
But it's clear, you issued him the citation or the warning. Sorry, I say citation, I mean them interchangeably, the warning. The
Yes.
reason for the stop.
Written warning.
And as that goes, then you turn it into an investigation, correct?
I think I was still in the midst of the entire traffic stop and the investigation of the traffic stop and everything that led from that traffic stop.
You knew at the time that you were issuing the warning that you were going to investigate that pocket further, correct?
Not until he admitted it was cocaine.
Well, if you said, no, it's not cocaine in my pocket, it's nothing, would you have just dropped it?
That's not what happened, though.
Okay, but you talked about before, when you were testifying before, what you would have done or could have done in past history and experience. But speaking of your experience, in this case, you would have wanted to investigate that based on what you patted down from before?
Yes.
Now, we don't know if Dante didn't say anything, but it's pretty clear from the video at this point that you mentioned you wanted to search numerous things, and that pocket was one of them, correct?
Yes, I asked to search all of his pockets, and he said no.
Well, initially, when you came up to this, you asked if you could search the ketchup packets, or bag of ketchup?
Yes.
Yeah. And then you asked to search the car, and he wasn't sure because it wasn't his car, correct?
No, he originally granted permission. That's why he got out of the vehicle.
Oh, well, okay. But you asked to search the vehicle because you wanted to search the vehicle.
Yes.
And then you asked to search his pocket, which he said no.
Due to his nervous behavior.
Well, you think that was nervous behavior?
Especially after having multiple conversations with him and him being withdrawn like he was on the traffic stop, yes. And then he gets out of the car and he starts to walk around the immediate vicinity.
Well, aren't people typically nervous when they're at a traffic stop?
Typically they listen to commands.
Didn't he listen to you?
Overall, but his demeanor of walking around, that's not typical of a normal traffic stop when somebody gets out.
I mean, didn't he just seem upset that it was something stupid like expired plates that his buddy had done that was upsetting him?
I don't know what he was feeling or thinking at that time.
Well, you're testifying that he was nervous, so you are testifying that you know what he was feeling.
Well, he was nervous in his the manner in which he was acting. It wasn't typical of a normal interaction, especially with somebody I know and I deal with at least every 2 weeks while working at the bars downtown.
Isn't it clear that he appears to be upset, not to an extended degree, but because he believes he's not going to have a ride home, and you inform him that you're not going to tow the car, right?
I tell him I'm not going to tow the car and we can give him a written warning.
Okay. But wouldn't that make people nervous if they think that their car is going to be towed or their ride is going to be gone?
Not after I tell him it's not going to get towed.
Okay, and after that, he seemed to calm down a little bit, didn't he? Like he didn't seem as upset.
No, he was still very nervous in my opinion, especially because of my past knowledge of Donta.
Well, you've asked to search, you wanted to search him 3 times. Don't you think that would make people nervous when an officer keeps asking to search him?
Your Honor.
Overruled.
I wasn't searching him, I was searching the car.
No, but with your inquiry into consistently asking to search things, doesn't that make people nervous because you want to search them?
Not typically.
Not typically?
No.
Do you ask everyone at traffic stops if you could search everything?
If their demeanor is making me believe there's something more than expired tags, which in this case it was 100% on that.
But initially you asked to search the car and that ketchup bag before he had given you any indication of any problems. I mean, when you're talking to him, he's not nervous sitting in the car, correct?
When I lit him up and he took so long to come to a complete stop and then he pulls forward again and he's moving around the car during that time, it makes me start to wonder what's in the car or on his person.
Well, don't people typically move around because they want to get their ID, their license, whatever it is they think that you might want to...
Not in that manner.
Not in that manner? Was there anything, when he was sitting there in the car, was there a lot of stuff around him when you looked in the vehicle?
There was not a lot of things in the vehicle. It wasn't a freshly detailed car, but it wasn't a hot mess either.
And what movement did he make? Did he just go reach over and get something from the passenger seat?
No, he was leaned up in the seat like this. There was moving around. You see his elbow at one point, consistent with possibly opening a center console, things of that nature.
Why don't you ask him what he was doing moving around the car?
On my initial approach, I wanted to advise him. I was pulling him over. I realized it was Donta, and as I continued to speak with him, I could tell something was off. He was not being his normal self, and that's why I transitioned to more of a...
You didn't ask him to get out of the vehicle. You asked to search the car, and he said yes, and he said, I'll get out of the car, right?
Correct.
Okay. And why didn't you order him out of the car if you thought he was moving around a lot in the car? I'm assuming you think he was... Strike that. Did you think he was hiding something or obscuring something?
Yes, based off of those movements, I think he was maybe moving something from inside the center console or somewhere specific in the vehicle and onto his person.
That's what you could tell from the movements?
I couldn't tell that, but that's what I would assume, or I was being led to believe.
Okay. You don't mention any of that when you approach him. It seems like a pretty amicable conversation.
Yes.
You didn't think he had anything on him until you felt something in his pocket, correct?
I mean, based on his demeanor, I knew something was not correct. Or something was off. There was something he was trying to be deceitful or hide from me.
And it was your goal at that point to determine what the contents of his pocket were. Is that correct?
No. So I wanted to do the consent search of the vehicle, like you told me. He's being very nervous. He gets out. He's walking around, looking around the area. I'm concerned at that point maybe he has a weapon on him or something of that nature.
Well,
I have another officer with me.
Your pat down's lawful, right? When he gets out of the vehicle for officer safety, you can pat him down.
Correct.
Okay, and you do that. But you don't search the vehicle at all.
I begin to, and then he starts to. He doesn't tell me no exactly, but I could see me searching the vehicle was upsetting him, so that's why I said I feel like you're withdrawing consent, sir, and I'm going to get you a written warning and try to get you out of here.
You felt he was withdrawing his, but he was just mentioning it's his buddy's car, correct?
Yes.
Okay, and it would be understandable that he doesn't know the contents of the vehicle, correct?
I mean, I pretty much know everything in any car I drive.
Well, if I let you borrow, say, my car, and you took it to the gas station, and say you got stopped, and someone wanted to say, hey, can we search the car? Wouldn't you be nervous because you don't know what the contents of my vehicle are?
I usually keep good company, so I would know if I was driving your car, I would highly doubt that there was a bag of cocaine in it, sir.
Well, yeah, but you wouldn't know, correct?
100% no.
Okay. So isn't it typical for someone when they're driving someone else's vehicle to be concerned about allowing you to search it because they don't know what on earth you could find?
Yeah, I mean, I guess he wouldn't check under every single seat and between seat belts and things of that nature.
Okay. Now, just to be clear, we hear the printing of the citation, we hear you tear it off, there's a little bit of time goes by, a short period of time, and then you folded the citation, you were handing it to him, and then you inquired as to the contents of his pocket, correct?
No. I'm print the ticket. As I'm folding it, that's when I begin having the conversation with him about what's in his pocket, and then he admits to having a bag of cocaine in his pocket as I hand him the citation.
And you had given him the citation, and then he told you what the contents of the pocket were, correct?
Correct.
No further questions, Your Honor.
Redirect.
Just two things to clarify. Mr. Deeb asked you about the pat down. You believed you felt drugs due to your past experience with Donta.
Yes.
Or is it your training and experience overall with your pat down?
Training experience and...
It was just heightened due to the fact of your past experience.
Objection.
Correct.
Overruled.
And he also asked you based on a prior arrest. Your plain feel isn't based on just this defendant, is that correct?
Correct.
Nothing further, thank you.
Recross.
Nothing further.
All right, you may step down, thank you. Next witness,
State of Ohio would rest, Your Honor.
Mr. Deeb, do you have anything to present?
No, Your Honor.
All right. Mr. Geiger?
Your Honor, the defense claims that the stop was extended. You got to see the whole thing. You heard where he's trying to find his insurance. It was 11 minutes. That's well within the time. Plain feel, the officer probably could have went in his pocket right then and there and took it, but he took more time to issue his ticket in case, he doesn't want to rush into anything. He believes that the defendant's withdrawn consent to search the car, so he doesn't search the car. We'd ask you to deny the motion. Thank you.
Mr. Deeb?
Your Honor, upon issuing the citation, the traffic stop was completed. They diverted it into a custodial interrogation, so we could ask him some questions about that. While it is brief, it is obvious that my client did not want to have himself searched. He was reluctant to have the vehicle searched because it's not his vehicle, but he was inclined to consent, but then not knowing it's his vehicle, it's obvious that he's concerned about that because he doesn't know what's in it. And then, or it appears that way from the video without his testimony, we don't know what he was thinking. But at that point, once they issued the citation and the warning was printed, should have been informed that he was free to leave, and he continued the interaction between the two, as it seemed fairly amicable for the most part up until that point. And the officer does respect his wishes not to search his pocket. And if it was immediately apparent that's what would have happened, that he would have taken action at that point. It wasn't immediately apparent based on the fact that he has a prior belief or arrest that he had had cocaine, and based on that, he made the assumption that whatever that he says powdery substance, whatever that soft object was in his pocket, he was going to be able to try and find out what was in that pocket. So we believe that he unlawfully detained him to complete that search upon the completion of the traffic stop, and at that point it should have been ended, and then the officer could have inquired further, but informed him that he was free to leave and give Dante that option. Instead, he unlawfully detained him continually after the warning was issued. Thank you, Your Honor.
Is your issue with the 11-minute stop?
No, the duration of the stop is not unreasonable. It's that the traffic stop was completed and then he continued it to investigate the pocket.
When was the stop completed? What's your argument as to when the stop was completed?
When he issued him the warning.
And how? And what was? When you say issue the warning, when does the issuance of the warning become complete?
When he prints the warning up and he has it, he folds it, he can give it to him. At that point, the traffic stop would be completed by handing it to him. By him doing any other action not in line with the traffic stop, it continues the duration. So if he prints the citation, doesn't give it to him, that prolongs the citation because it's completed. All he has to do is hand it to him. There's nothing that they need to do in furtherance of the traffic stop at that point.
All right. The officer testified that as he could hear the tear of the paper from the machine, and he begins his conversation with Mr. Smith as he is completing that and folding it, and in the process of handing it is when this conversation starts. Is it your position that once it leaves Officer Brown's hand and gets into Mr. Smith's hand, that is the absolute bright line completion of that stop?
Given that he's issuing him warning, there would be no further reason to go forward with any conversation.
That's what I'm asking.
Completed. Yes.
So Officer Brown's testimony is the conversation begins, they're talking about what's in his pocket. Once the paper leaves Officer Brown's hands and enters into Mr. Smith's hands, that's the bright line where the conversation should end, even if it was mid-sentence or not mid-sentence.
At that point, it's completed, and if he wants, he should inform him that he is free to leave and the traffic stop
Well,
is over.
does he have
bright
to?
Line test. Yes, I'm saying that he should.
But to your point, does he have to inform, does an officer have to inform anybody that he or she stops that the stop is complete and you're free to leave? Do they have to use those words?
I don't think they have to use those words, that they have to make it known to the person, because at that point, a reasonable person wouldn't walk away from an officer engaging them after they had been lawfully stopped until they feel free to leave.
Well, but say any other say you're going 115 on Route 2 and the State Highway Patrol gives you a ticket, they write you the ticket, they hand it to you. Once they hand it to you, do they have to say, okay, you can go now, or you just can get it and go?
It's based on the traffic stop, Your Honor. If he handed me the citation, he was explaining it, you need to go to court, you have time to waive it.
Right.
Certain things like that would be permissible, but since he was issuing a warning, at that point there was nothing further to say. And he doesn't have a conversation regarding the traffic citations.
All right. Well, your position is, regardless, once that paper exchanged hands, it's a bright line, and that should have ended everything, and nothing else can happen as a result after that?
I'm not saying nothing else can happen. I'm saying the officer should inform him.
In this case?
He should have informed him that the traffic stop is over, and it goes from there. Okay. Yes.
But I want to make sure you're clear on what you're saying. Was it Officer Brown's obligation to inform Mr. Smith once he handed it to him that this stop is ended and you're free to go?
Yes.
Okay. All right, I'll take it under advisement, issue a written decision.
May I?
Yeah. What?
The officer was well within his rights to have a consensual conversation with him.
Alrighty, well, Judge just ended that feed. However, he did say that he was going to take it under advisement and issue a decision later. So we're not getting an answer today. It was an interesting hearing, though, and I'm curious to know what you think. So let me know in the chat. Would you side with the state or the defense on this one? Actually, you know what? I'm just going to put up a poll. So give me a moment, and I'll put up a poll. But in the meantime, let's go to Florida, Judge Mercer.
Mr. McCage, good morning. Mr. McCage, you're here for first appearance accused of one count of breach of the peace and one count of trespass after warning. Mr. McCage, I read the complaint. I was not sure it was an arrestable offense, Mr. McDaniel, to that very last sentence that says he was still on the property when the officer got there. So I think there's probable cause. Mr. McDaniel, anything you want me to be aware of?
I agree. I think it's a close call on the trespass, and I think the breach of peace is probably a close call. I mean, on anything, I guess, because of free speech case law and stuff, but I don't know if there's anything like really that caused a major disturbance or any kind of disturbance except for him holding up a sign. But, with that being said, I understand the court may, rule the other way.
And so for bond purpose, we're just asking for a bond today, Mr. McDaniel?
Yes, Your Honor.
Thank you. And I don't disagree with you all on the breach of the peace. I think that's a closer case. I don't think that the sign is, I don't think that's a breach of the peace under Florida's case law, but going into an open business, allegedly causing a disruption in a public area may be close enough. I don't know, but there is probable cause for sure on the trespass. Mr. Mitchell, what's the state's position?
Your Honor, it logged me out on this one, but when I was looking up Mr. McCage earlier, it looks like he actually has an open and pending case in Columbia County for loitering and prowling, very similar charges.
Do you know if he's on bond or release? Or
I had it.
Civil ticket. They gave him a notice to appear. He's got a court date, I think, later.
Okay.
The 8th, if I recall. It was just a notice to appear.
He's not on any kind of pretrial release. He was not arrested, Mr. McDaniel?
Okay. Yeah. Then no issue.
I didn't see that he was arrested.
Thank you. Mr. McCage, I think you're entitled to a bond in this case. Your bond's going to be $5,000 on the trespass, $2,500 on the breach of the peace. Your total bond today is $7,500 cash or surety, Mr. McCage. And you have a condition not to go back to that property where you allegedly were at, that you were allegedly instructed to leave. You'll get to use the phone in a few minutes, sir, to try to post a bond. Mr. McCage, do you have any questions?
Yeah, I'm on a medical bond for that. The deal.
Columbia County?
No. Oh, that was just a ticket. No, in Calhoun.
He says, I didn't see anything in Calhoun. He says they gave him.
I got the paper in my
Calhoun
deal.
County,
I got bad grandma seizures, and I've been to the hospital 3 times in 3 or 4 days now. And I'm just trying to go to Kentucky where my mom's at. And
you have over 50 arrests, so the chance of me giving you a conditional release is 0. All right. Have a good day. Next case. Yeah, let's give him notice for his court date too, please, Corporal. His court date will be the next misdemeanor date.
July 27th.
July 27th. What were you saying, Don? The breach of the peace is $2,500 because it's a much not as strong a case. Ryan Beavers.
I think the jail sheet's wrong. I think his first name's Christopher, and that's his middle name that's on there.
So the jail sheet says Ryan Christopher, and you think it should be Christopher Ryan?
Yeah, I think it's Christopher Ryan.
Mr. Beavers, is it Christopher Ryan or Ryan Christopher?
Christopher Ryan.
Okay. So, Corporal, we need to try to get that straight. The VOP affidavit is correct. It has Christopher. So, Mr. Beavers, you're here because you've been accused of violating the terms of your state probation. Mr. Beavers, the circuit judge has signed a warrant for your arrest with no bond. I'm going to go ahead and arraign you on that this morning because I want to get you a lawyer appointed if you're asking for one. Mr. Beavers, would you like to have an attorney appointed to represent you?
Yeah.
Is it? Okay, Mr. Beavers, I'm going to appoint the public defender's office to represent you. Listen to Mr. McDaniel, and I'll see if you have any questions in just a minute.
No, we're going to plead not guilty. He has to set this in August 6th court docket, and I advise him to be an attorney to come by and visit him prior to that hearing.
August 6th, Mr. Mitchell, anything?
No, Your Honor.
Mr. Beavers, August 6th, your attorney will see you before your court date. Any questions, sir?
Yes, sir.
Have a good day, sir.
Tafawa.
We have Tafawa Redding. Mr. Redding, good morning. Mr. Redding, you're here for first appearance, charge of 1 count of driving under the influence. Mr. Redding, there is probable cause for the charge. I'm going to appoint you the public defender's office to represent you. I understand that you are already out on bond out of Bay County, and there may be additional charges coming that you're aware of. Mr. McDaniel, anything on behalf of Mr. Redding this morning?
Nothing, Your Honor. We just asked for a reasonable bond.
Mr. Mitchell?
I don't know if this court wants to go ahead and do that, but the Bay County office has been in touch with our office and wants us to move to revoke his Bay County bond. If you're inclined to do that, that's what we're moving for today.
Last year, the judges unanimously agreed that any judge within the circuit has authority to revoke bonds for cases within the circuit. So I'm going to revoke the bond based upon what I'm seeing here for Bay County case 26-911 CF. I need an order revoking that bond from either you or Bay County office, Mr. Mitchell.
I'll get it to you today.
So, Mr. Redding, your bond on the DUI is $5,000. Go ahead, Mr. McDaniel.
Judge, if we were holding off, I guess, to see if they were going to revoke his bond or not. If the court's going to revoke his bond, I think Mr. Redding tells me that he just wants to go ahead and enter a plea of no contest to this charge and accept the court's plea of 60 days in the county jail.
Okay. Mr. Redding, I'm going to revoke your bond whether you plea or not, based upon the new charge that you've been arrested for. Now, whether you plea is a totally different question, but you need to understand your bond's going to be revoked this morning. Knowing that, do you want to take the offer that was made to you this morning, sir?
I have no choice.
Well, you do have a choice. The choice is to sit there with no bond for Bay County, and then you can post bond here and go deal with the Bay County charge first. If you plea, you're going to deal with our sentence first before you go to Bay County. I'll set your bond to $5,000 on the DUI if you wish, if you want a bond, and then we'll see what happens. If you post bond, you'll go deal with Bay County. But I am revoking your bond in Bay County.
I see what you're saying. Okay.
So do you want to post bond and deal with Bay County first, or do you want to plea and get this one resolved and deal with Bay County later?
I mean, let's get this one over with. Yes.
Okay. Mr. McDaniel, did you put it on the record already?
I did.
Mr. Mitchell, is that 60-day sentence agreeable with the state?
60 days is agreeable with the state, Your Honor.
And Mr. Redding, that is the plea you would like to enter. Is that right, sir?
I think he's muted.
We'll just one day because he was arrested yesterday.
Judge, he's changed his mind. He don't want to do right now. So we'll just ask for a bond to set.
Okay. So your bond is $5,000 cash or surety in Jackson County. You have no bond for Bay County. Mr. Redding, if you post bond, you'll go to Bay County. If you don't post bond, you'll deal with this case first. If you're still here, you'll be on a jail arraignment docket. Otherwise, I want to ask the jail to give you a notice for your arraignment date, which will be the 27th.
He would be in jail because his bond's revoked, and that's
no, I'm assuming he's going to not be in our jail. July 27th will be your court date if you're out of custody. July 27th at 9 a.m. The jail will give you that notice, Mr. Redding. Have a good day, sir. Next case we have is Shaughness Ivy. Mr. Ivy, good morning. Mr. Ivy, you're here for first appearance. Good morning. You're accused of one count of grand theft motor vehicle, one count of felon in possession of firearm. Mr. Ivy, there is probable cause for the charges. I think you're entitled to a bond, Mr. Ivy, as far as I can tell. I know that you got out of prison fairly recently. I also looked at the DOC website. I think you've been to prison 8 times, but you're still entitled to a bond as far as I can tell. I'm going to listen to the attorneys, Mr. Ivy, then I'm going to set you a bond. Mr. McDaniel, anything on behalf of Mr. Ivy?
No, Your Honor.
Mr. Mitchell?
No, Your Honor.
Mr. Ivy, your bond on the grand theft is going to be $10,000. Your bond on the felon in possession of firearms is going to be $25,000. Your total bond, Mr. Ivy, is $35,000 cash or surety with a condition of no contact with the alleged victim of the grand theft. Mr. Ivy, you'll get a chance to use the phone in a few minutes, sir, to try to post the bond. And if you don't post the bond, the public defender's office will see you at the jail. If you do post the bond, then you'll be given a notice for your court date. Felony court date would be when?
August 4th.
August 4th at 8:30 will be your court date. Mr. Ivy, do you have any questions?
No, sir.
Wish you the best, sir.
Yes.
We have Tiffany, Clement,
Robert Sislak.
Okay. We do have an add-on that's not on the sheet. The jail told me they had a waiver of extradition that they had left off the sheet this morning that's getting out. I think he's Mr. Sislak. I think is finishing his sentence this weekend, so they want to go ahead and deal with a waiver of extradition. What state is it from, Corporal or Mr. McDaniel?
Seminole County, Georgia.
Okay, and it's Sislak. Is that how do you spell his last name?
Sislak.
Sislak, Cislak.
Cislak. So, Mr. Sislak, my understanding is you have a warrant out of Seminole County, Georgia, and Mr. McDaniels talked to you about the waiver of extradition process. You've been brought up today because you're going to actually finish your sentence here on the weekend, apparently. Do you have any questions you would like to ask me about that process?
No, sir.
And do you want to waive extradition to the state of Alabama, or do you want to contest it? Georgia.
Waive it. Georgia.
I'm sorry, I'm confusing. The Seminole County, Georgia. My bad. What is that? Is that Bainbridge?
That's
Donaldsonville. All right. So what we're going to do is let you sign that waiver, and we'll get that to them today. As you know, they have 30 days to pick you up. But under our rule, what we do here is we review the cases at 15 days. That's strictly just to keep an eye on things. Considering how close they are, it's very unlikely you'll still be here in 15 days. But if you are, I'll see you and we'll ask the jail what's going on with transport, okay?
Yes, sir.
I need to get your first name also, Mr. Sislak. What's your first name?
Robert.
Thank you, sir.
Tiffany Clements, and she's on her way, Your Honor. All right, we have
Ms. Clement, good morning. I'll let you sign that. You go ahead and sign that, ma'am, and then I'll make sure you don't have any questions. Ms. Clement, you have a warrant out of Lauderdale County, Alabama, ma'am. I believe you probably just signed a waiver of extradition. Is that right?
Yes, sir.
Ms. Clement, do you have any questions about that waiver of extradition, ma'am?
What exactly does it do?
They have, when you sign that, you're saying you're willing to go back and deal with these allegations against you. You're not you're not pleading anything or admitting anything. You're just saying you want to go back and deal with this. That puts them on the clock to pick you up. They had 30 days to pick you up. That 30 days starts today. If they don't pick you up within 30 days, you're entitled to be released. But I'm not sure where Lauderdale County, Alabama is. Anybody know how far north that is? The closer it is to us, usually the quicker they'll pick people up. So what we do is, if you're still here in 15 days, ma'am, you come back to first appearance. I'll ask the corporal, what have we heard from Lauderdale County? Do we have a tentative transport date? You'll hear that answer when I hear it. There's also a good chance you won't be here within 15 days. There's a good chance they will have already picked you up. When you get back to the state of Alabama, they will advise you if you have a bond, if you're entitled to a bond or not. I've been told under Alabama law, you cannot post bond until you're physically present in that state. You can't, even if you have a bond, you can't post it until you get back there. So that 30-day time limit starts today. Any questions, ma'am?
I do have a question.
Okay.
Just hang on. Let's.
Okay.
Judge, she has other questions, but she'll ask those after.
I'm gonna wait.
Yeah, she's waiting to write.
What you're saying is that you're willing to go back and deal with this. If you don't sign this waiver, they can get up to 90 days to pick you up. If you sign this waiver, you're saying, I want y'all to go ahead and come get me so I can deal with this when I get there. That's what you're doing. Any questions?
Not on that issue.
Not on that issue.
All right. Have a good day, ma'am.
She wanted to say something else, Your Honor. And
okay, go ahead.
Yesterday morning, I was strangled and raped, and I fear for my life, and I'm not feeling well. I need medical attention. I was trying to go to a safety facility.
Okay. So I was out of pocket yesterday, and Judge Roberts signed a warrant regarding another first appearance case. Is she the alleged victim in that case?
No, this is not something that's been filed, Your Honor. I think there's some. This
is a search warrant.
Oh, search warrant.
Yeah.
There may be a search
warrant. But the allegation she's talking about, she made, which led to a search warrant yesterday that I couldn't sign, Judge Roberts signed. So, Corporal, you're aware that she's accused, and that may be why she didn't come in the same room. Y'all are aware of that concern, right? Sergeant? Okay.
Yes, sir.
So, ma'am, as far as your medical needs, you made the jail aware of them on the record. As far as going to a facility, we have zero authority to let you out when another state wants you. We simply cannot do that. We don't have authority to. if Alabama, the state of Alabama sends us something to do something like that, we certainly can do it. Otherwise, you're going to be held until Alabama picks you up, ma'am. Okay?
Okay, can you see if Alabama will send something to release me?
I don't have, no, ma'am. That's something your attorney or your family or the jail's got to do. It's not something the judge is going to do. If Alabama wants to release you and they send us something, that's okay. As of yesterday, they wanted you held. So it would surprise me if they want to release you as of yesterday. I don't know that it says what the warrant is for, but they clearly say we'll come get her. Corporal?
Judge Mercer, I spoke to him this morning on the phone. I'm waiting on a call back from them to decide if they are going to pick her up or not.
And they're aware of her circumstances?
Yes, sir.
So that brings up the last thing. Go ahead, Mr. Daniel.
I mean, they're aware that if she doesn't go to Alabama, she has to go to the hospital.
So, ma'am, Ms. Clement, the last thing is if they contact the jail and say, we've changed our mind, we looked into this and y'all can release her, you'll be released. Usually that's got to be in writing now. But if that happens, you'll be released immediately to the hospital or wherever. You will not go to Alabama. You don't come back to first appearance. You just get released. Now, that happens rarely, but it does happen every once in a while. Otherwise, you're going to be held for Alabama, okay?
What's he saying to me?
So just to let you know, when I'm referring to the hospital, I'm referring to the mental hospital because our people were saying that she's extremely delusional and, our mental health people and that she's got some major issues. I'm not, no bearing, I guess, whether something happened or didn't happen, I don't know, but I just know that if she gets released from here, she's going to go to the mental hospital.
Thank you, Mr. McDaniel. Mr. McDaniel, I know we've got one sentencing in the courtroom, but was it Mr. McDaniel involved in that sentencing?
Yes.
Yeah,
Troy Johnson.
he was first appeared, yeah.
Okay, so we'll do that in just a second. Anybody need the jail for anything else? Corporal, do you have anything else?
No, Your Honor.
Thank you, Corporal. We'll see you next week. We have this one actually, I guess I won't see you, but I've got them this weekend. Been looking forward to having first appearances on the weekend. So I'm assuming you don't have them though, Corporal. You're 5 day a week guy, right?
Yes, sir. And we're not, me and Mr. Groves ain't gonna be here next week, so.
You say neither one of you will be there?
No, sir.
Who's
got a vacation
planned
together? Stuart and.
Whatever training. Work related.
Officer Whitakerson will be covering or somebody totally new?
No, it's Whitakerson and Lieutenant Stewart.
Okay. We'll miss y'all. Hope y'all enjoy your vacation.
Yes, sir.
Thank you. We do have one case that was a sentencing today at State versus Troy Johnson. Mr. Johnson, come on up, please.
Mr. Johnson.
Mr. Johnson is coming up. Mr. Johnson entered a plea of no contest to the charge of driving while licensed, suspended, or revoked. The plea offer or the state's recommended sentence was a jail sentence, and I was going to do that. And then Mr. Johnson had some pets that were, according to him, had been left alone in a home or a building without any food or water. So we were trying to take that into account since he was charged with a non-violent offense. I agreed to accept the plea and set sentencing for today. Is that all right? Is everything I said pretty much accurate, Mr. McDaniel?
Yes, Your Honor.
And what was the recommended disposition from the state when he pled?
It was 10 days.
10 days. So you're here for sentencing, Mr. Johnson. Mr. McDaniel, anything I need to be aware of before I impose sentence, sir?
Your Honor, just, we'd ask the recommendation of 10 days in jail, 5 days jail credit, $400 fine.
Mr. Mitchell, anything?
No, Your Honor, and that is agreeable.
Mr. Johnson, do you have anything you need to tell me, sir? Anything
No,
you're thinking
sir.
of?
Well, I
So
appreciate you.
I'm gonna do exactly what we told you we'll do since you showed up on time. I appreciate that. I'm gonna judge you guilty of that offense, sentence you to 10 days in jail, but you have 5 days credit. You've already served 5 days. I'm gonna give you court costs and fines will be imposed of $400. You'll go to jail today. When you finish these 5 days, you're done with this case. There's no probation. You're through with this case.
No fine, no nothing.
The court costs and fines will be a civil judgment if you don't get them worked off at the jail. In 5 days, you may get the court costs and fines worked off. That's something you talk to the jail about. But if you don't get them worked off, there'll be a civil judgment against you, which means your driver's license could be suspended for not paying them. But you have 60 days from the time you get out of jail. You have 60 days when you're going out of jail to pay them or enter a payment plan to avoid a suspension of your driver's license. That time doesn't even start until you get out of jail.
I'm gonna pay that, then I can go and get my license reinstated.
Right, exactly. But hopefully you'll have enough time to work the fine off while you're at the jail by volunteering at the jail and not have to pay it. So that's what I would suggest you check into.
Oh, okay. I'll talk to somebody at the jail about
When you get
what do you
booked-
call that?
It's called the trustee program.
Oh, they'll do it for 5 days?
I don't know. They might. It's worth asking.
Mr. Johnson, they're probably not going to. So, I mean, when you get done with this, you need to enter a payment plan for this case and that other case. You can get your license back reinstated. You know what I mean? So you can start making the payments because you just owe some money to get your license back. So, I mean, you need to get some kind of payment plan on those cases so you can get your license back reinstated. Because if you get caught driving, you're going to be right back in jail.
I understand, sir.
So what he's talking about, a payment plan, when you get out, all you do is go to the clerk's office and say, I can't pay all this up front, but I can pay so much per
I did it
month.
last time, but the thing was.
So you know how it works.
The problem was, that's why I'm back in jail now, because that somebody that got into my account, I couldn't get no money out of my account, checking out savings.
Well, how were the animals once you got to them when y'all let you out last week?
They was happy to see me.
They
was happy. The manager of the apartment complex, he went to check on them because he knew I had got put in jail.
They took make sure they had food and water. Was it 2 pets or more than that?
No, I got somebody staying in the apartment with me this time for 5 days.
How many pets are you talking about?
I got 2 service animals.
Okay. All right. Any questions?
No, sir.
All right. If you'll go with the sergeant, I wish you the best, sir. Okay.
I appreciate you, Your Honor.
Yes, sir. Wish you the
And
best.
thanks for doing that when you did last week, okay?
Yes, sir. Appreciate you showing up on time today. All right. So, Mr. McDaniel, I think that's it for the weekend. Excuse me.
Good morning once again, everybody. Hour 2 of TCF Live on this Super Friday. We saw this guy earlier, and it's good to see that he showed back up on time, so that worked out well. CWS gifted a couple of memberships. Thank you for that. And then the comment, it's a great channel, just usually a little too early for me. Thank you for calling us a great channel, and I got to be honest, it's probably a little bit too early for me as well. It's killing me. I'm doing it, but it's killing me. No, it's I love getting up early to spend this time with you guys. It's totally worth it. Barbara also earlier today, $10 super chat. Thank you for that as well. Okie dokie, let's move along. Let's go to Texas, Judge Stevens.
Mm-hmm.
Did you do it on the budget?
Oh, yeah, we did it on me on that. I know, right?
Okay. So 3 cases are going to be dismissed.
Yes, sir. And pleading the 2.
You did pretty good there. But still, you got 2 cases that you're stuck with. He's going to plead to which numbers?
The cause numbers are 24 GCCR 1018 and 1019.
And the other 3 shall be dismissed, which are 1079, 1712, and 1716.
That's correct, Judge.
Five cases are now called all style of the state of Texas versus, is it Trevon? Trevon Joshua Clark in each of these cases. And you are going to be pleading guilty in 24 CR 1018 and 1019, which are a first-degree felony of aggravated robbery and a third-degree felony of evading arrest or detention with a motor vehicle. Is that your understanding of the plan, sir?
Yes, sir.
Does the defendant, who is here with Mr. Adams, licensed Adams, waive formal readings of these indictments and arraignments here? Can we proceed in summary? Yes. That'd be a yes.
Oh, yes, sir. Yes, sir. I apologize.
That's what I thought you was. I knew you were thinking that. I just. All right. In summary, 24 CR 1018 states that on or about May 2nd, 2024 in Jefferson County, Texas, you committed the first-degree felony of aggravated robbery. So I understand what you are charged with in this particular case.
Yes, sir.
Stand by. This is a first-degree felony, isn't it?
Yes, sir.
It's checked off as a second degree. That can't be. It says, see, second degree. I'm gonna fix that. That's okay with everybody?
Yes, sir. Yes, sir.
Nice try, though, from the defense. It's always working for his client. This is a first-degree felony because it alleges that you intentionally and knowingly threatened or placed the victim in fear of imminent bodily injury or death.
Yeah.
And in the course of committing theft, and you used a deadly weapon, namely a firearm. You face, as a first-degree felony, a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range applicable here?
Yes, sir.
An agreement's been reached in your case. You would be pleading guilty. Sentenced to 8. This is 8. 8, right? 8 years in prison to run concurrently with another case. I guess this third-degree felony of evading arrest. And then it says, and Fed robbery. Is that right? You have a case in the federal government, the U.S. Attorney's Office, where you're charged with robbery?
Yes, sir.
Okay.
It was 18 USC 2119 for carjacking.
Have you been sentenced to that one?
He has.
What did you get sentenced for?
It's the same case.
No. What was the sentence? What was the amount of time you were?
96 months.
That is
96
correct.
months. Okay.
So the idea is that they run the same amount of time to run concurrent.
Okay. So was that 8 years?
Yes, sir.
8 years. Okay. You're going to get 8 years here, but there's a big difference between the federal parole and the state parole. Here, you're going to have to serve half your time, at least 50%, because a firearm was used in the connection of the crime.
Yes, sir.
In the federal government, you're going to spend a longer time because their parole rules are different. And you have to spend almost 90% of your time before you are released, and you have to have good behavior, certainly. But this agreement, again, is you would be sentenced to 8 years in prison to run concurrently with other cases, state and federal cases. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case, do you understand?
Yes, sir.
How do you plead to this charge, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily?
Yes, sir.
That is on your own free will because you are guilty.
Yes, sir.
Yeah, I'm going to put that one aside for just a moment and go to 24 CR 1019. And again, the defendant waives a formal reading of this indictment, a third-degree felony, and agrees to proceed in summary. Correct?
Yes, sir.
All right. In summary, this indictment also similarly states as the previous indictment that on or about May 2nd, 2024, which wasn't a good day for you, I guess. In Jefferson County, Texas, you committed the third-degree felony of evading arrest or detention with a motor vehicle. I guess when you were fleeing from the aggravated robbery that they were chasing you. If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed and not to exceed $10,000. Do you understand? The agreement's been reached in your case. You've been pleading guilty, sentenced to 8 years in prison to run concurrently with the prior case we went over a few minutes ago and with other federal case or cases. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this case, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is from your own free will. And because you are guilty.
Yes.
Show you what's marked as State's Exhibit 1 in each of these cases. Did you sign those documents?
Yes, sir.
Understand them, discuss them with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence in each case.
No objection.
Without objection, admitted. Among other things, the state, sir, that you are mentally competent to enter your guilty pleas, though freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You were guilty of these crimes and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true at State, so help you God.
Yes, sir.
State's Exhibit 1 is part of the record for all purposes. Pre-sentence reports are waived.
Yes, sir.
If nothing further to add, I'm going to find Mr. Clark on each of these cases. You have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty pleas from State's Exhibit 1 admitted in each of these cases to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of the first-degree felony of aggravated robbery in 24 CR 1018. And in the third-degree felony of evading arrest or detention with a motor vehicle in 24 CR 1019. I am following these agreements. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 8 years. And in each of these cases, and these sentences shall run concurrently. In 24 CR 1018, the aggravated robbery, the judgment shall reflect an affirmative finding that a deadly weapon, namely a firearm, was used in the commission of this offense. I think that covers it all. You understand what has happened today, sir?
Yes, sir.
I do better.
Yes, sir.
Okay, that is all.
Thank you. Good luck.
Alrighty, still in hour number 2, about halfway through the show here, TCF Live on a Super Friday. CWS, thank you for becoming a channel member. Tim, celebrating 6 months of membership. Thank you for all of the support you've given us. Very much appreciated. And Lindsay, 14 months of membership. Says, still so happy to be here. Lindsay, I'm happy that you're here. You know, I talk with Beth all the time about how this has developed and, you know, the people that we have around us and all the support we get. And Lindsay, yours is one of the names that comes up a lot because I just can't imagine this space without you being a part of it. So thank you. Okie dokie, let's change it up a little bit. Let's go to Georgia. Let's check in with Judge Carnesale.
Okay, so are we ready to go forward on Mr. Morris?
Yes.
Okay, is there an agreement or do we need to schedule an evidentiary hearing?
There is no agreement, Your Honor, not as to sentencing. We will, however, stipulate that he's been arrested for the new offense.
So you want to enter a blind stipulation and just leave the sentence to me?
Yes, Your Honor.
Okay, that's fine. All right. Do you want to present the petition, Ms. Levinsky, and what you're asking for, or do you want to do it, Ms. Smith?
I will do it, Your Honor.
Okay.
Your Honor, Mr. Herbert has been violated for the offense of commission of the offense of possession of cocaine and possession of one or Schedule 1 or 2 controlled substance with intent to distribute on October the 6th, 2025.
Okay.
No, that case has not been indicted. Mr. Herbert will not admit that he committed the offense. He will admit that he has been arrested for the offense.
Okay. All right. And Ms. Smith, what are you asking for today? Or do you want the Officer Julius to present that?
I can, Your Honor. In this case, the state is asking to revoke 6 months and to reinstate the balance. The reason why we're asking to revoke 6 months in this case is because it's my understanding that the defendant entered a plea back in 2010. He spent the next 14 years incarcerated in prison. And within those first 20 months of being released from custody, the defendant was arrested for the violations we have before us. I did get a chance to look at the warrant in this case, where the defendant is alleged to have went to his workplace and placed a book bag in a locker. And that book bag that the defendant is seen on camera having had marijuana and also field tested cocaine in the backpack, along with multiple baggies, a scale, indicators pointing that there is some type of intent to distribute. The state believes that because of this new arrest, the defendant is not taking probation as seriously as he should, especially after spending the last 14 years incarcerated. So that's why the state is asking for the 6 months in this case to be revoked and also for the balance to be terminated. I'm sorry, the balance to be reinstated. And that is all from the state.
Okay. And Officer Julius, do you have anything to add?
No, Your Honor. My original recommendation was 4 months. After speaking with Ms. Levinsky, before getting that information that Ms. Smith just shared with us, I did state 3 months would be a good recommendation. But now with this new information from Ms. Smith, I would go back at least to my 4 months recommendation.
Okay. Okay. Ms. Levinsky?
I'm not sure what information would have been new, but Your Honor, Mr. Herbert was convicted of an offense committed when he was 17 years of age. 17 years of age. He spent 14 years in prison. He was released in November 2023. He came out of prison and has basically done everything he is supposed to do. He has got himself a job and he has got on with his life. He has been arrested for a new offense and he denies the commission of the new offense. The new offense has not even been indicted. His current situation is that he works for UNIS Warehouse. He is engaged to be married. In fact, were it not for this arrest, he would in fact already be married. He was supposed to have been married a week after his arrest on the probation violation. his fiance, who should have been on the Zoom call, her name is Tina Burney, had to cancel the wedding, and she is in fact 4 months pregnant with a high-risk pregnancy. The new offense, in inverted commas, that he's charged with is a possession of
cocaine
and a Schedule 2 controlled substance, Schedule 1 or 2 controlled substance. The way I read the warrant, it was marijuana. As far as I'm aware, nobody actually has a GBI report from any of these substances. He was not, in fact, found with the substances. They were found in a bag, which they to him, and he was not, in fact, at the premises at the time.
Was that your client who just stepped out? Did he just step out of the booth?
I don't believe.
Oh, I'm sorry. Okay. Go ahead. That wasn't your client.
Somebody else did.
Okay. Okay. So could you hear all of that, Mr. Morris?
Yes, ma'am. Yes, Your Honor.
Okay. All right. If you want to stipulate today that you were arrested on these charges and stipulate for purposes of a revocation, I would do something in the middle. I understand what the lawyers are saying, and the prosecutor's not wrong about a 6-month recommendation. It is warranted when somebody's been incarcerated for a long time, gets out, and then immediately has new charges. But I heard what Ms. Levinsky had to say about you've got a child on the way. So what I would do if you want to maintain your stipulation is revoke 4 months and reinstate.
Yes, ma'am.
So back to the original. So you don't have to do that. We can have a full hearing with evidence. Then I could make a decision once I've heard the evidence. But if you want to stipulate, that's what I would do today.
All right. Okay.
You want to talk to Ms. Levinsky more? Do you want to talk to her a little bit more?
So if I take the 4 months today, how much time would I have to do?
I'm not in charge of calculating your time, but it looks to me like you have about a month. Is that right? That's how long you've been in?
He's been in 40 days.
40? Okay. And I don't know, I'm not in charge of calculating your time, whether you get day for day or not on these. But you'll definitely get credit for the time that you've been in there. And then you can check with the jail about calculation of your time till you get out. So do you want to stipulate, or do you want me to set up an evidentiary hearing? Because that's no problem. You have a right to it.
We can stipulate.
Okay. So I'll find that you're stipulating that the state could prove you were arrested on these charges to a preponderance of the evidence. And we're going with revoke 4 months and reinstate. And is there anything else we need to add, Officer Julius?
No, Your Honor, I just need to get some information from the defendant.
Do I get a 2-for-1?
So I can't say. I'm not in charge of that. I don't calculate your time, but we're going to mark that you get credit for time served, and you can check at the jail. They're the ones who are going to calculate your time. Is that right, Officer Julius?
Yes, Your Honor, and he will get the credit for, yes, he will get the credit for time served.
Okay. So if you want to talk to Ms. Levinsky again, you can. She might know better than I do, but I don't have any authority over that at all.
Yeah, I would like to talk to Ms. Levinsky.
Okay, we'll put you back in the breakout room again.
Thank you, Your Honor.
No problem.
Well, that was a very entertaining lawyer. I could listen to her all day if for no other reason than to try to figure out exactly where that accent is coming from, because as we were talking about in the chat, it's kind of hard to pin down. TCF Live, hour 2 here on this Super Friday. Lot of new people out there today. If you have not yet said good morning, please do say good morning to us in the chat. You'll find us to be a friendly folk around here. As well, if you have not already, please do consider going to the link in the pinned chat. That is TCF Court Watch. It's something we launched this week. It is an enhanced viewing experience. You get the same stuff on YouTube that you on Court Watch, but you get more. So check it out. When you first land there, do look at the FAQ. It kind of explains everything. And Rhonda Ann becoming a channel member. Thank you so much for that. Alrighty, let's go back to Judge Stevens, new contestant there.
For some of them, but they're amusing nonetheless. I don't know what you're doing in here, ma'am. I'm Miss Arredondo. I'm a mid-county boy, and we mid-county people shouldn't be here in these courts. All right, fix it.
Yes, sir.
25 CR 875 is called the State of Texas versus Ashley Nicole Arredondo, present with Miss Minaldi, Carroll County, and the State's Attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes.
In summary, this indictment alleges that on or about April 15th, 2025, in Jefferson County, Texas, you committed the second-degree felony of burglary of a habitation. Do you understand what you're charged with here?
Yes, sir.
I don't have anything yet. It's somewhere.
There you go. It's floating around, waiting to go to your.
It's in the universe.
Yeah.
Hasn't gotten to the solar system yet.
I have error message going down. If I can't use this, not at all. Sign up your bad. I look like that.
You know, this stuff tastes terrible.
I would imagine so. I can't speak from your new too.
It's hand sanitizer.
Judge, I'm done. That's not alcohol. That's
What? It has a minty fresh taste.
I'm gonna get the probation department in here for you.
Good luck with them trying to stagger their way in here. In the first try. Just kidding. Just kidding. No, we laugh about it, but alcohol use. I don't drink alcohol. I'm not. I don't do that. So I'm not.
And that
I'm not a proponent of that. Certainly, it has its place, but you don't want to misuse it.
It looks like that.
Then it makes you act silly and uncoordinated, and you don't want to drive a 4,000-pound missile around town when you don't have all your faculties. Too many of those cases end up in this court, and there's a lot of weeping and crying and people asking for their loved ones to be brought back to life, which I can't do. It's part of the horrors and sadness of what happens sometimes in the court. Thank you very much. Oh. Again, in summary, you were charged with the second-degree felony of burglary of a habitation, and that means if convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand what you're charged with and what you were facing as punishment here, Ms. Arredondo?
Yeah.
Fortunately, you have a good lady representing you, and she has made a deal with the district attorney's office that you would be pleading guilty, but not found guilty. You would be placed on deferred or unadjudicated probation for a length of time. It can be up to 10 years in length. And there would be terms and conditions of probation, which are normal and customary for this type of offense. I think I'm reading what this other X is on substance.
Is that for the assessment? Substance abuse assessment?
Is that abuse?
You're making fun of my handwriting, Judge?
You will give it I don't see a B. That's a B?
Would you like for me to try to rewrite it, or do you want to rewrite it?
Put that error message report shuts you down
What error message?
on your screen. Roll it to like 3 hours or something instead of 15 minutes.
Stand by. I can only go snooze 2 hours.
Okay.
But I must say, I don't think I've ever seen that box before.
We're working on some.
What is
things, but
it?
I think they just-
I've got an alarm clock up here. Oh, I mean, next you'll have a night light for me or something. Okay, is that your understanding of the plan, man? If I follow this agreement, you have no right of appeal of your case. Do you understand? How do you plead to this? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty? Yes.
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document?
I did.
Understand it, discuss it with your attorney, or the contents all true and correct?
They are.
State's Exhibit 1 is tendered
No
into
objection.
evidence without objection if it's admitted. Among other things, this states that you are mentally competent to enter your guilty plea. It's voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. Read it. You're guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses.
Yes.
You were totally satisfied with the representation provided by your lawyer. All of this, it states it's true. So help you God.
Yes.
States Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived here.
Yes, Judge.
Okay, I'm going to follow this agreement, but we got to clarify, what are we going to do on length of time?
I agree to the 5 years.
Do you?
Yes, sir.
All right. If nothing further, I'm going to find that you are pleading guilty and you are entering your guilty plea freely and voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. Even though there's enough evidence here to support your guilty plea, to find you guilty beyond a reasonable doubt, we're going to give you another chance and place you on deferred or unadjudicated probation for 5 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. First of all, though, we're going to, as a beginning, evaluate you with a substance abuse evaluation from the probation office to figure out where the weaknesses are that we have to strengthen so that you can complete this probation successfully. If you fail, your probation can be revoked. You can then be found guilty and sentenced up to 20 years in prison. So there's a lot riding on doing good things. Now, I'm going to sign the probation office, the probation order here in a minute. You're going to go over them with the probation office. There are some 35 conditions of probation, but strangely enough, and I always tell people, don't be horrified. 30 of those I have to follow.
Yeah.
Which begins with don't commit a crime.
Yeah.
Don't deal with disreputable people. Yeah. Curfew. Don't be out late at night with nothing to do, getting in trouble. You know, it's the kind of thing that's a blueprint for good behavior and also for staying out of trouble and successfully completing your probation, which is what we want. Have you ever been convicted before? If you're convicted of a felony, you know how long that lasts? The rest of your life. And wait, yeah, if you ever did that, all types of doors of opportunity are closed off.
Understood.
You don't want that. Fix this.
Yeah.
Do better. See the probation officer. Thank you.
Yes.
I don't see a fine.
No fine. No fine.
There was no fine.
Yes.
Okay, that's fine. If she's arrested, she can go back in jail.
She was next door.
Yeah, she was one.
She was next door and this would be important.
Doing what?
I guess she had to know.
Where is she? What were you doing in another court? This is felony court. What were you over there for? Well, you have a responsibility to be here at 9 o'clock. We revoked your bond. You're under arrest. You got to figure that out. If you're going to be in two places at once, you got to tell somebody. But the court order was to be here at 9 o'clock. You weren't here. I don't care what they said. You had a court order. They don't have a court order with me. The order of this court was on you, ma'am. You're the one that's supposed to be responsible, but you're here with a felony, which is irresponsible behavior to begin with. But you've got to fix this mess up. That's your mess. When you got different courts, that means you're making messes. You have the responsibility to fix. I'm not going to go find you. I ordered you to be here at 9 o'clock and everybody else was here. Everyone else, except you. You got my attention. You weren't here at 9 like you were supposed to be. It's a court order. It's like being held in contempt. You violated an order. I revoked your bond. You have a warrant. You are in arrest. Sit in jail. That's what's going to happen. Come on up.
And Judge, I do have a request of reinstating her bond since she was here down the hall.
I'm going to deal with her at the end.
Okay, Judge.
She comes at you.
Yeah, you're in the penalty box right here. Okay.
Real quick, everybody sing along with me at home now. My court's bigger than your court. My court's bigger than yours. Now that'll be stuck in your head all day.
I'm in misdemeanor court. In misdemeanor, you can go up to jail. You can be ordered to go to jail for 1 year. Here in this court, you can get the death penalty or life imprisonment. Which one do you think is more important? And in your case, what's she charged with?
State jail.
Yeah, you're looking at 2 years, up to 2 years in the state jail. But relax, sit there quietly. We're going to get to you in a little bit, okay? And we'll try to fix all of this. I think we covered it, theft prevention, no problem. Okay.
Thank you.
Do something else. All right, who's next?
I believe that's all I have besides Ms. Thomas.
Check, because I thought Kenesha said 500. Was there a fine or no, guys? You're in both things.
Was there a fine on there? I didn't put one.
Oh, you do that?
No.
I had 500. I didn't catch it on there.
Nobody's.
I had 500.
It wasn't on the papers, and I didn't say anything. What
That's
y'all
correct,
wanna
Judge.
do?
I didn't catch it on there.
Should there be one or not?
Right.
No, Judge, it's fine. I didn't catch it.
Usually don't.
Run like the wind.
Yeah. The cloud police are. I'm gonna plug in your.
Okay, let me go. Come on up.
Yeah, I'm gonna plug it in. Zach took mine to fix it.
That's my document. That is my pad. I lost my pad.
For us, and that way I need to do it for the.
He took my pad. I'm padless.
Ms. Thomas.
You know what it's like to walk around padless? It's embarrassing. The prosecutors know what it's like. They did that all the time. Okay.
This is Tamia Thomas, Judge.
You ready?
My request would be to reinstate her bond, being as she left here in the house.
Do you have did I give you the file file?
It's right there on the list.
Put that over there. They're saying they did. That means you, Kendall, was the remaining suspect. 25 CR 274 is now called. Tamia Thomas, that's you? Present with Ms. Manaldi, your attorney and the state's attorney. What are we doing today?
Judge, I have an updated offer from Ms. Moore, but I have
How's that?
not been able to relay that to my client.
Talk to her.
Okay.
Okay.
If you'll give me a few minutes.
Yeah, she's cleared. Yeah, I'm pulling all of that
Okay.
previously. I'm
The bonds are
the
reinstated.
bond revocation and the order for her arrest. See what y'all can do about resolving this. Thanks.
I'm ready.
All right.
I'm ready.
Come on up.
All right. That's all Mr. Hardwick. I'm ready.
That's three readies.
Hey, ready.
You must be
Huh?
ready.
I am ready. I am ready. I had that one with Mr. Ham. And I recognize the PO is here too.
The what?
The PO.
Who's here?
The PO.
How do you spell that?
There you go, right there. He is live and in color.
What are we doing?
It shouldn't be long. It's a hearing, but
Oh, we're gonna have a hearing on it?
yeah, but it's not.
Oh, okay. I thought there was an agreement. No?
No.
Come on out.
We have witnesses stage.
Great. Okay.
We may want to do it at the table. Not to tell you.
Hold on. Is everybody else, does everybody else have hearings?
Rent out.
That's mine.
Are you ready?
I don't know if it will be a
Oh, okay.
resolution today,
Okay.
Judge. I
Well,
just need to
we're
talk.
gonna go into this
Okay.
for a while. All right. We call Courtland Hardwick. That's you, sir?
Yes, sir.
Okay. And you were here with Mr. Adams, your attorney,
Yes.
and the state's attorney. There is a motion to revoke probation that has been filed as of March 24th of this year. And it alleges that you have failed on your probation in 6 different ways: by committing burglary of a habitation, by indecent exposure, failing to report to the probation office, failing to provide verification of community service hours, failing to provide verification of entering and successfully completing the batterers intervention and prevention program. We call that BIP, and failing to pay court assessed fees as directed. All of these were conditions of probation that the court had ordered you to follow based upon your conviction here, upon your plea of guilty to the 3rd-degree felony of injury to an elderly person. A 3rd-degree felony that you were indicted for. Do you understand where we're standing here? We're going to have a hearing on these violations that are alleged. All right, y'all have a seat, and let's put on the evidence that needs to be presented. Thanks.
Yes, sir.
Brent, for moving. Appreciate you. All right. Once again, in 22-40987, the state of Texas versus Courtland Julian Hardwick. You're Mr. Hardwick.
Yes.
Here with Mr. Adams, your attorney, and the state's attorney. Mr. Hardwick, raise your right hand. Do you solemnly swear or affirm that any statements that you might make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, lower your hand. Does the defendant waive a formal reading of this motion to revoke probation? Can we proceed in summary?
Yes, sir.
In summary, this motion to revoke probation, again filed on March 24th of this year. In summary, it states that on July 25th, 2023, in this criminal district court of Jefferson County, Texas, you were sentenced to 10 years in prison. That was suspended, and you were placed on regular probation for 10 years for the 3rd-degree felony of injury to an elderly person. Is all of that true and correct? Correct. Yeah, speak out so she can hear. Okay. Allegation 1 states you committed the offense of burglary of a habitation on or about February 15th, 2026 in Jefferson County, Texas. in violation of condition 1 of your probation order. And your probation order number 1 states commit no offense against the laws of this state or any other state or of the United States. Is allegation 1 true or untrue?
Untrue.
Untrue will be put into the record on your behalf. 2. Allegation 2 states you committed the offense of indecent exposure on or about February 15th, 2026 in Jefferson County, Texas, in violation of condition 1 of your probation order. Is that true or untrue?
Untrue.
Untrue will be placed in the record on your behalf. 3, you failed to report to the Jefferson County Probation Office for the month of January 2026 in violation of condition 4 of your probation order. Condition 4 states report as directed by your probation officer and obey all rules and regulations of the Jefferson County Probation Office. Is that true or untrue?
Not true.
4, you failed to provide verification of performing community service hours as directed in violation of condition 18 of your probation order. Your probation order number 18 states that you shall perform 600 hours of community service. And anyway, you have required community service obligations as part of your probation order. And is this allegation true or untrue?
Untrue.
5, you failed to provide verification of entering and successfully completing the Battering Intervention and Prevention Program. We call that BIP, B-I-P-P, in violation of condition 27 of your probation order, which states complete BIP and pay all associated costs. Is that true or untrue?
Untrue.
And finally, this says in number 6, you failed to pay court assessed fees as directed, and you are, as of February 17th, 2026, in arrears $2,735 in cost, fees, and other assessments as part of your probation. And that is in violation of condition 35 of your probation order, which states pay the amounts required in this probation as set out in this order. Is that true or untrue?
Untrue.
That's okay. Untrue is written and is written into the record and placed into the record on each of these allegations. State may call your first witness.
Ronnie Williams. At this time, we will vote the rules.
There are no other witnesses besides the probation officer, Jeff.
Okay.
Yeah. Raise your right hand, sir. Do you solemnly swear or affirm the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please have a seat. Thank you, sir.
Yeah, that works.
Thank you.
All right.
Go ahead.
Go ahead and state your name for the record, sir.
Ronald Williams.
All right, so I'm gonna just adjust that microphone a little bit and ask you to it's a direction delivering less for the 40%. If that's right. There's a way to follow it. All right. All right, if you're gonna hold it, don't hold it. Close it back.
Yeah, I'm gonna try that.
All right.
Hold on for just a second. I'm gonna.
If you want to mess with it, go ahead.
That's probably. I had it that earlier.
I know, everybody moves it around with it.
Yeah. You gotta. No.
All right, so
Stand by.
I apologize.
Getting the real time court reporting displayed here so I can read along.
I'm fixing to have a blast.
Okay, and again, you were Ronald Williams?
Yeah.
All right, I think when I called you, I called out the name Ronnie Williams. Do you go by Ronnie?
I go by Ron.
And your official name is Ronald Williams?
Yes.
Is it spelled Ronald?
Yes.
Williams is the common spelling? Is that a yes?
Yes.
All right, you're doing good. Where do you live, sir? Do you live here in the city of Beaumont? I don't want to get into the specific street address, but is that on Chamberlain Drive?
Yes, it is.
Okay. Do you remember an incident that occurred on February 15th of 2026?
Yeah. Yes, sir.
Okay. And did this incident occur at your house?
Yes, sir.
You are the owner.
My mother was the owner.
Okay.
She's passed.
But you are the one that currently lives there? And is there a lady that lives there in that house as well?
Yes, sir.
And what's her name?
Teresa Hayes.
All right. So what happened on February 15th, 2026?
I go to get us something to eat, me and my girlfriend. And when I come back, I'm back in the driveway. And he's coming from across the street down the driveway.
Hold on, who's he? So I wasn't there.
Slim, though, I know him, but I don't know him.
Do you see him in the courtroom?
Yes, sir, I do.
And what is Slim wearing?
Orange jumpsuit.
Is he the gentleman at the end of this table with the dreads?
Yes, sir.
Governor, may the record reflect he's identified the defendant.
Yes, it will.
All right, so you see Slim as you know him, and what's Slim doing?
He's walking up his driveway toward Chamberlain, which is right across the street from my house.
Are y'all neighbors?
Yes, but I don't think he actually lived there. He was, I think, visiting the people that did live there.
You've seen him out and around?
Seen him and I had said hello to him. That's it. I don't know him, you know.
Right. So you see him coming, and what's he do?
So I'm sitting there listening to a song on radio. I'm going to finish listening to it. So
that's you in your car, sir?
yes, sir.
Okay.
I'm in my car. And so he turns like he's gonna go down to college, but then he stops and he comes right through my yard. What did he do? So I open the door, I get food, go towards my front door. By the time I got there, he's at my front door. And I asked, what are you doing, man? So I open the door and he just goes right on up in my house. He goes over and lays on my couch.
So let me stop you there, and I know you've got more to say, but did you invite him to come into your house?
No, I didn't invite him to come in.
So all this was his choice. He just walked through your yard, came through your door.
Yes.
Lays down on your couch.
The objection is that's gonna be a misstatement of testimony. I thought I heard his testimony was he opened the door. So when he opened.
I did open the door.
Hold on, everybody. When there's objection, I got a rule on it, then you're gonna have a fair opportunity to be heard. What's your objection?
Judge, the legal objection is that's a misstatement of the testimony because the client said he opened the door. So it's not like my guy's forcing himself in there. He opened the door.
The court will note what the record shows, and you will have a fair opportunity to present evidence, Mr. Adams.
Thank you.
When it's your turn, and to cross-examine. And the court will determine what the facts are. Go ahead.
So to be clear, Mr. Williams, you're not saying he forced his way into your house.
And he tried to burglarize or do any of that kind of stuff. He just come in, he'd lay down on my couch. I'm like, what the hell is he doing?
Right.
You know?
And again, he wasn't invited.
No.
And so once he does this behavior, do you find it out of the ordinary that this guy just walks in and lays down on your couch?
Yeah, of course.
So what do you do when that happens?
I told him to get his ass up and get out of my house.
Did he do it?
Not at first. He just laid there. And then I kind of got a little bit lighter, told him, get your ass up and get out of my house, dude.
Right.
I don't even know.
Right. So at this stage, you're getting upset about some guy you don't really know laid up in your house.
Yeah.
Does Miss Hayes come into the room?
Yeah, she's standing.
hallway right there going into the living room.
And so what happens? What's next?
She told him to go down herself and he's there and leave.
Let's stay away from what she said. What's the next thing that takes place?
Well, he finally gets up and he comes to the door, which I had done opened it, had the door open.
Trying to shepherd him out, right?
Yeah. So he turns around and pulls his shorts down and shakes his crap at my girlfriend.
Now let's.
He done that.
I'm gonna need you to be specific. He pulls down his shorts and he shakes what? Let's use the
pain.
Thank you.
We're adults here, it's not gonna embarrass us too much. But we need to know exactly what you're a witness to. Thank you.
Remember, Mr. Williams, it's all about holding somebody accountable for the conduct. He shook his.
Evidently his mind wasn't right or something.
All right. Don't go guessing. This man pulls his shorts down and waves his penis at you and Miss Hayes.
Yeah.
Were you offended by that conduct?
Well, of course I was.
So you're already upset about him laid up in your house doing this. Now he does that. What do you do?
Get out of it. Yeah, I hit him and knocked him out the glass, the screen door.
Knocked him out of your house?
Knocked him out of my house and he lands out there in the yard. So I run out there and hit him. And then my girlfriend was telling me to stop. And so I did, but then he jumps up and runs on across the street. And I told him, well, he was dead out of here.
You ever apologize for that conduct?
It was like 3 nights later, there was a knock on the door. I'm thinking that one of the TVs. It's him. I'm like, what the hell? I said, man, get your ass out of here, dude. And he did. That was about it.
Any doubt in your mind that whenever he was in your residence, that you gave him notice that you wanted him out, that he was an unwelcome visitor?
Could you repeat that?
Is there any doubt in your mind that when all this is taking place, you let him know you wanted him out of your house?
Well, yeah, no.
And he didn't do it initially. You basically had to force him out.
Well, yeah.
What?
Yeah.
I mean, your punch
Yeah.
took him out of the house.
Yeah.
And all that conduct that he did was not by your consent, meaning you didn't agree to all that to happen, correct?
No, I didn't agree.
So some of the questions we have to ask about legal elements are kind of wordy, but that's what I needed to ask you, sir. It was without your consent. Just like him exposing himself to you and your girlfriend, Miss Hayes. Y'all found it indecent and it was inappropriate, correct?
Yes.
And all this occurred within your residence there on Chamberlain here in the city of Beaumont within Jefferson County, Texas, correct? That's Williams.
How you doing, Mr. Williams? You doing okay?
Yeah, I'm doing okay. Yeah.
All right, my name is Langston Adams, and I represent Mr. Courtland Hardwick, and he's to my right, all right? All right. Now, when I heard you testify, I wrote down 3 things that I heard come directly out of your mouth, all right?
Okay.
And not anybody saying this but you, okay?
Your Honor, I'm going to object to the format of this question. We don't need Mr. Adams to repeat what he believes. We need questions and answers.
Hey, overrule. Go ahead. So again, before the objection was made, I noticed 3 particular things that came from your mouth, and I want to go through those particular things, okay?
Okay.
Right. And you also heard the judge say that I have opportunity to cross-examine you when we mentioned some of those things, right?
Yeah.
All right. One of the things that came out of your mouth is that when my client approached the door to your home, you said you opened the door. Was that correct? That when you said that?
Yeah.
All right. And another thing that I heard that came out of your mouth, you said word for word I'm not saying he was burglarized in the house. Do you remember when you said that? Right?
Yeah.
And that came from your mouth. And then another thing that I heard you say that came directly from your mouth is you said apparently, to use your exact words, you didn't say apparently, your exact words was evidently he was not in his right mind. Do you remember you saying that, right?
Yeah.
All right. So just beginning my cross-examination with those three things that you said, and it was unsolicited by me, it was under direct testimony with Mr. Ham. Let's talk about when you said evidently he was not in his right mind. Did you know that he suffers from bipolar disorder? Did you know that?
No, I don't know the man. How would I know that?
I got you. Did you know that he suffered from schizophrenia?
I have no idea.
Did you know that he suffers from PTSD? All right. And did you know that he suffers from anxiety disorder?
Sir,
I got you.
I have no idea about that man.
What's a no?
The answer is no. And did you know that he went to Spindletop MHMR for treatment? Did you know that?
Ooh.
All right. So in terms of let's talking about what you do know, I think Mr. Ham had asked you something to the effect of was he one of your neighbors? So my question to you is prior to this incident in February of 2026, when was the first time you had any contact with my client ever?
Well, I really can't answer that question. I mean,
He can't answer it.
month or
Answer.
two,
Got you.
a month or two before, or a couple months.
So in that month or two that you had known him before or seen him around before, how would you describe him?
I mean, I really can't say. I just said hello and he said hello back. That's basically about it.
Okay. So if I understand your testimony, you identified him as Slim. Is that something that you used to call him in the neighborhood?
That's what I knew him by, Slim, yes.
And how did you get to know him as Slim?
By neighbors. I heard them calling him, so.
Okay. So basically, this is a guy that you've seen before in the neighborhood, and you heard neighbors call him Slim. Is that right?
Yeah.
All right. So in that month or 2 months or however long that you've been knowing him, had you ever seen him to do anything out of the ordinary? All right. So here's a guy that you've known at least for a month, 2 months.
I did.
Well, not knowing personally, but you. I got you, but you knew of him as Slim, right? And even though y'all didn't have a personal relationship, within that 2 month period, you did not see anything out of ordinary with him. Is that right?
That's right.
All right. So then when we get to this particular day, obviously something happens out of the ordinary, right?
I think so.
Right. And when you said that, hey, I'm not saying that this is a burglary or anything like that, because when we talk typically of a burglary, you got somebody forcing their way in your house, they want to steal something in your house, something like that, right? Right. But in this case, what you got is a guy who, according to you, evidently he wasn't in his right mind. According to you, you open the door, he walks in your house, he sits down, and he's not in your house trying to steal nothing out of your house, right?
Yeah, right.
He's not in your house saying that he want to fight you or beat you up or threaten beat up Miss Hayes, because I think under your testimony with Mr. Ham, your testimony was, in fact, you hit him when he took out his penis, right?
Betcha. And he's lucky. I mean, somebody else might have shot him there.
Yeah, well, no doubt about it. And I totally understand that. I totally understand that why you would be upset if you had a man in your house who you had let in. He sits on your couch or sofa, whatever he's sitting on, and he's displaying what you call to be irrational or, behavior that's not rational, right?
That's right.
All right. And I can see why you'd be upset about that. And at the end of the day, what you have here is Slim, who you know as Slim, as somebody who appears to be psychotic, right?
Can you answer that?
What can
Do
you
know
answer
what
that?
psychotic means,
Yes, sir.
medically?
Well, but
Can you answer that? Can you answer what you understand psychotic to mean?
Or do you have the ability to make a psychological evaluation of another person?
I'm not asking him to make one.
Qualified to make that statement, Jay.
Do you have any medical training at all on this? Okay, but you got experience in life.
yeah.
All right.
Right. And
Yeah.
based upon your rule,
I'm sorry, the objection is sustained. He doesn't, you're asking him, we're gonna go into psychological questions that he is unable to ask.
I'm not
but
going to.
we're just talking about
I'm not.
figuring out what the facts are in this case. He doesn't have the qualification to make a medical or psychological determination. So go ahead. He's a witness to what he saw and he's doing the best to try to explain it. Go ahead.
All right. So you understand that you're not a doctor, you're not a psychologist, you're not a medical provider, you're not a counselor, right?
That's right.
Right. But you are a lay person, right? You're a person with common sense, right? You got eyes, you got ears, you got your senses, you can see, right? And you don't have to be a doctor or psychologist to see something strange, right?
Right.
And in your own words, you said apparently he was out of his mind, and that you're not a psychologist to be able to see that, right?
Apparently, I thought he might be on something, you know.
Gotcha. So do you understand that I'm not asking you to make a medical diagnosis? I'm asking you to tell me what you saw with your own eyes.
I done told you that.
Okay, and I'll move on. Thank you for your time on that. Miss Teresa Hayes, did she provide any statements to the police, to your knowledge, as to what she saw or did not see? Because I don't see why I got it.
She wrote a statement.
Oh, she did write a statement?
Yeah.
And do you know where she is right now? Is she available?
Yes, she.
Okay. As far as with him taking out his penis, is it your testimony that he was doing that just because he's out of his mind, or he was doing that for some type of gratification? Do you know?
I don't know why he done that.
Right. So I'm sorry, go ahead.
I have no idea why he done that.
Gotcha.
But he should.
I got you. So your testimony under oath is you don't know what was the reason for doing that. It's just that he evidently wasn't acting in his right mind. I got you. With that being said, Mr. Ronald Williams, I thank you for your time. I appreciate you.
All right. Your Honor, I ask that you be excused.
All right, you are excused, sir. Thank you. Next, please.
Let's just Ruiz. Thank you, sir. You can go.
And raise your right hand, sir. Do you solemnly swear or affirm that the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hand. Thank you.
All right, so let's get you state your name for the record. We'll check the microphone here.
Jesus Ruiz.
Oh, good. And what do you do for a living, sir?
I am a community supervision officer here in Jefferson County.
And how long have you been working in that capacity?
About a year and a half.
And in that time frame, have you had an individual by the name of Courtland Julian Hardwick on your caseload?
Yes, I have.
Do you see him here in the courtroom today?
Yes, I do.
Can you point to him and identify something that he's wearing?
Orange suit.
You want
I
to
don't have a legal objection, but I couldn't hear him when he said the time period that he had my client. I didn't hear.
Yeah, could you repeat that? The time period that you were
How long have you had him on your caseload?
Since I started.
Which was how long?
A year and a half.
Okay.
Year and a half.
So approximately 18 months?
Yes.
All right.
Been his probation supervisor.
Yes, sir.
So back to, I believe that you identified the defendant, Your Honor, may the record reflect that?
Yes, it will.
Thank you, Judge. All right, so, Mr. Ruiz, in general, how was Mr. Hardwick, as far as going, how did he do on probation?
It was pretty good.
Okay. Was he compliant with what he needed to do?
For the most part, yes.
Now, I see from the administrative hearing that, we did have one prior administrative hearing where, I think we were dealing with him in Spindletop.
Yes.
Has he been compliant with that? Medication, things of that nature?
Up until this new offense, yes.
All right, so this new offense is from February 15th to 2026, correct?
Yes.
All right, did he report to you that he was arrested on these charges?
No, he did not.
Okay. So let's, how did you learn about it?
I saw it on the police report, on the arrest report.
And was it after that you processed this administrative hearing and the motion that we're dealing with here?
Yes, I did.
All right. And you're a part of the mental health initiative caseload, is that correct?
Yes.
So for the purposes of the record, tell us what that means.
So I'm the mental health initiative officer. My caseload involves people on probation that have mental health issues.
All right, so they are competent, correct?
Yes.
And
Objection, same objection that he raised. He's not qualified to make a medical diagnosis as to whether or not.
I will read the phrase. Sustain, he's gonna rephrase. Okay, it had been answered, and he can amend his question, and your objection sustained.
your knowledge was, well, okay, do you get people on your caseload that are incompetent?
Yes, I have.
Where they've previously been found incompetent, but they have to be competent to be dealt with in the court system, right?
I would imagine so, yes.
Are you familiar with that? Okay. So let's go to the other accusations. You alleged in the administrative hearing that he failed to report in January of 2026.
Yes.
When was he scheduled to report?
Can you ask the question again, please?
All right, so the accusation is that he failed to report in January, for the month of January 2026.
Yes.
My question to you was, when was he supposed to report?
On January
8th. Okay, did he report? Did he contact you about failing to report?
Yes.
So tell the judge what happened with this accusation.
During that time, he had been sick with COVID, with a host of illnesses, and he was in contact with me about nothing to do with the report.
Did he contact you before, or were you contacting him after he missed that appointment?
Oh.
Okay. But you've alleged that he failed to report.
Yes.
Okay. When was he scheduled? When was his next appointment?
2 weeks afterwards.
Did he show for that?
No.
So he missed January 8th, and then he missed January 22nd? Are there any other, that's a yes?
Yes.
Did he miss any other dates in January?
No.
Were those excused?
No.
So they are considered failure to report,
yes.
Correct? Okay. Let's go to his community service hours. He's been on probation on this matter since July 25th of 2023, correct?
Yes.
And am I accurate that his probation order states that he was to do 600 hours of community service?
Yes.
And that, as with everybody else in the department, it's recommended that he do 50% within the first year.
Yes.
So by July of 2024, he should have done 300 hours.
Yes.
And be well on his way to completing that. Where's he at on community service?
Completed 4 hours so far.
So out of the 600, he's done 4.
Yes.
When was the 4 that he did?
On December 24th, 2024.
None since then?
No,
Any excuses why?
he was working.
Did you confirm that he was working?
Yes,
So that connects with then his ability to pay court assessed fees, right? You had proof that he could pay?
yes.
Why wasn't he paying?
He had a lot going on.
That's what he was telling you? All right. We all have a lot
going on.
We all
What's
have a
that
lot. Yeah. Did you excuse his arrearages?
No,
But he could have paid according to the information you have.
yes,
He was working
yes.
up until he got arrested on this.
I'm not sure up until he got arrested, but months before he got arrested, yes, he was working.
Okay. And you confirmed it.
Yes.
All right. So let's go to the last.
Hold on.
Yes, sir.
Just let me get clear on something, since these are parts of the allegations of the motion to revoke probation. On the community service, he's completed 4 hours.
Yes, sir.
And 4 hours, and that is from the time he was placed on probation on July 25th, 2023, essentially 3 years ago.
Yes, sir.
4 hours.
Yes, sir.
3 years. That's a grand total of less than 1 hour a year.
That's a yes, John. Yes. He's nodding his head, but he's not answering.
Okay. All right. And what did he say? He was busy doing other things?
He was working.
Working.
Yes.
What was he doing for work?
He was working at KFC.
Frying chicken?
Yes.
Was he working 24 hours a day there?
Not to my knowledge. No.
Okay, it was like regular 8 hours shifts or something?
Yes, sir.
Okay. Did you get income statements from him? Were you able to get income statements?
No, sir.
So how do you verify he's actually working? And other probationers? How did they just tell you? I mean, trust, but we verify, right?
Yes, sir.
Okay, what we've done to verify what he was actually doing, especially in light of the fact that he must be he apparently, according to him, was working so hard he can only do 1 hour a year of community service.
Well, multiple times when he reported in his KFC outfit. His attire that he wore to KFC.
And that was his, not something he found on the road?
I cannot confirm it.
Okay, so we really don't know because, all right. Okay, and as far as arrearages and money, what was the total amount of money that he paid for his costs for being on probation during these 3 years?
He has a total credit of $307.
Okay, so a grand total of about $100 a year.
Yes.
Okay. Which is a grand total of about 30 cents a day.
Yes, sir.
Go ahead.
Batters treatment program. It's alleged in this motion that he failed to provide verification of entering and successfully completing. What's going on with that?
So he didn't qualify to do the intervention program, so we had him doing the anger management program. Something he did complete, he showed that he completed, but I never got a certificate for it.
Why didn't he qualify for batters intervention program?
There's certain stipulations with batters intervention that qualify you or don't qualify you. And when I spoke with my supervisor, she advised that anger management would be better suited for him.
Okay. When did y'all make that change?
This was done before, well, I found out about it, but this was done before I started working.
Okay. And he claimed that he did it?
He came into my office during one of the reporting days and he showed me on his phone that he completed the 8-hour anger management course. Yes, but I never got a certificate of completion.
Is that the purpose of this? Is that we don't have proof, we don't have verification that he successfully completed the program?
Well, objection.
Oh, wait, hold on. Well, he asked a question. What's your objection?
Legal objection is that that misstates the testimony when he asked him when you don't have verification. He did have verification because he showed the phone and what he completed. That is verification that he, and the guy acknowledged that he completed the anger management program, and my client showed him the phone that documented where he completed the program.
Okay.
He just said that.
Okay.
So he does have verification.
Okay, overruled. He can answer the question and you can follow up with your questions. Yeah, unless you want to take the stand. I don't know, okay.
Does the department accept people showing them something on the phone? No. It's a good indicator that maybe they did it, right? Yes?
Yes.
Is that a yes? And did you give them instructions about that you needed actual verification?
Yes, sir.
Did you ever get it?
Yes, sir.
And to be clear, it wasn't for the batter's intervention program, it was for the anger management program, which is 8 hours.
Yes, sir.
The batter's intervention program is a much longer program, isn't it?
I'm not sure.
Okay. You're not that familiar with that one, are you?
No.
That's
Before we go on, let me get something clear on this, since it states in the motion to revoke probation, failed to provide verification of entering and successfully the battering intervention and prevention program. What are we doing with that?
He explained in his testimony, Judge, that the department changed that requirement to the anger management.
When did I sign that? I didn't order that. I ordered batter's intervention. I didn't order. Is there something? I know y'all changed that, but y'all, it's my order.
Yes, sir.
The courts, the district judge's orders. I can't see an amended order anywhere here. My order is for him to complete batter's intervention. Now, things can change, but it says 27, complete BIPP, batter's intervention prevention, not anger management. I mean, he's not ordered. He wasn't ordered by me to do that. He was ordered by y'all. That's not. I don't think that's valid. That's apples and oranges. When they change it, I think I have to verify it, and he's under my direction and my orders. Yeah, that's not the way I want it done, and I don't think any of the judges want it done that way. Y'all can change that without getting the approval. But I'm looking, are you certain there wasn't an amended order sent? Does anybody in probation? I'm looking through here. That's what I didn't order him anger management, and that's what the testimony is. But the allegation is BIP, and they're not.
I don't know what the PSI says, but the general condition for that says the BIP program or an approved anger management, but I don't.
I have
that was done.
27 complete BIPP is handwritten in blue ink and pay all associated costs. I don't have any other program.
Nope.
I think I don't think we're talking apples and oranges. Yeah. I know they're similar, but but apples don't want to be called an orange. Yeah, I don't see any other amendment here too that modified that. But that has to be run by the motion to revoke probation is alleging violations of the court ordered probation terms, and that wasn't ordered by the court. And so thus anger management is a good thing, but it's not what was required by the court. And the allegation is BIP violation. He didn't violate the BIP. He didn't take it, but he was told to do anger management, and he did that. I don't think how that can be used to violate as a violation of probation.
a lot of the testimony, Judge. I'm going to abandon count 5. If that's the install.
So with that being said, you do agree with Judge Stevens and understand that the state is now abandoning 5, and I go with the rest, that without Judge Stevens' approval, you guys told him to take anger management when the court required him to take the BIP program, right?
Yes.
And that's the probation department that made that decision without the court's approval, right? Right?
Yes.
All right. So with that being said, since the state has abandoned 5, we'll now move to 1, 2, 3, 4, and 6. Okay.
Yes.
All right. Now with Mr. Ham, he mentioned that you had my client for 8 months, and that 8. I'm sorry. I apologize. You're correct. 18 months, and that you are one of the people who work on the mental health. I think you call it initiative caseload.
Yeah.
Is that right? So with that being the case, I'm assuming you have some specialized knowledge about people with psychological and mental health conditions that everybody else don't have because you got assigned to this particular unit, right? Why were you assigned to this particular unit?
Thank you. That was a better question.
Why?
I was hired on as the mental health initiative officer.
Okay. Do you possess any knowledge or training that deals with people who have mental health issues?
Not qualified, not certified, no.
Okay, so you don't have any particular, so you're saying that the Jefferson County Probation Department hired somebody to work with mental health that has no credentials, no qualifications, nothing with dealing with mental health people. That's what Jefferson County did, right?
We don't prescribe or guide.
I heard you, but I got it. You don't prescribe, but you assigned to this particular division, and in being assigned to this particular division, you have no kind of training, seminars, nothing with dealing with people with mental health issues, right?
Correct.
That's all I want to know. All right. So now, with you mentioned that my client was going to Spindletop MHMR. What do you understand Spindletop MHMR to be?
It's a mental health clinic.
And what do they do?
Providing mental health diagnosis and medication.
All right. And I want to follow on the same line of questions that Judge Stevens asked you when it came to verification. Remember when he was asking you, how do you verify employment? And you was talking about how he comes in the KFC uniform, and how do you know that was the questions of the judge, right?
Yes.
All right. So I'm going to ask you the same line of questions when it comes to MHMR. Do you verify any type of mental health illness?
Yes.
Do you verify who the doctors are?
Yes.
Do you verify any prescriptions that was given, right?
Yes.
So with you doing that, and I'm just following Judge Stevens' line of question. Just answer your question. Okay. Did you verify and did you know that my client suffers from bipolar?
Yes.
Did you verify and you know that my client suffers from schizophrenia?
Yes.
Did you verify and did you know that my client suffers from post-traumatic stress disorder?
Yes.
And did you know and verify that my client suffers from anxiety disorder?
Yes.
Right. Now, specifically, since you verified, who were the doctors at Spindletop MHMR that he was seeing?
He was seeing Dr. Chan.
Dr. Tran?
Yes.
And specifically, what medications was he prescribed and what do they treat?
He was taking oxcarbazepine.
And what does that treat?
Okay,
so oxcarbazepine is what you said?
Oxcarbazepine.
Oxcarbazepine, that's one. Okay, what was the other one he was taking?
Gabapentin.
You said gabapentin?
Yes.
And what does gabapentin treat?
That is for his anxiety.
Anxiety? Any other medications was he receiving?
Hydroxyzine.
Hydroxyzine? And what does that treat?
That's for his mood stabilizing.
Mood stabilizing? And what else?
And trazodone.
Trazodone. And what does trazodone treat?
That's a sleep medication.
That's a sleep medication?
Yes.
Okay. With him having a known diagnosis of schizophrenia, did you know that he hears voices?
Yes.
And did you know that sometimes he sees things?
Yes.
And did you know sometimes he hears voices and sees things that aren't really there?
Yes.
Right? Now, with Mr. Ham indicating that you had him for, as I corrected myself, 18 months, while you were dealing with him, did he display any kinds of behaviors that you would have considered to be unusual?
Whenever he reported to the office visits?
Yes.
Or whenever I saw him out on the field?
Both.
Nothing.
Nothing. And did you hear Mr. Ham's first witness? Because you were in the courtroom, right?
Yes.
Remember when I said, revoke the rule, and then Mr. Ham says only one witness, and that would have been you and Mr. Williams. So you heard the whole testimony, right?
Yes.
All right. And then you hearing the whole testimony when Mr. Williams was here, and I wrote down what you say. Say evidently.
What's your question?
My question to you: did you hear? That's a question. Did you hear that witness say evidently he's out of his mind? Right? You heard him say that, right? All right, and you heard that witness say, "I'm not saying he's trying to break into my house." You heard him say that, right?
Yes.
And you heard him say he opened the door, right? You heard all of that, right?
Yes.
And so if we look and we focus on, because remember the state has abandoned 5, so now I'm gonna focus on 1 and 2. If we look at February the 15th of 2026, you have a 18-month history with this man. At least according to Mr. Ham on the questions, right?
Yes.
You have opportunities to see him in the field. You got opportunities to deal with him one-on-one in your office, right?
Yes.
And in that 18-month period, you, by your own testimony, has never seen anything with him that even resembles what the testimony was on February the 15th of 2026, right?
Yes.
And that's your personal knowledge, and that's what you got absolute knowledge of because you were there. You got your own eyes. You saw what you saw, right?
Yes.
Right. So when you first learned of what happened on February the 15th of 2026, did you say to yourself, man, this can't be my client? I've never seen anything like that before, right?
Mm-hmm.
Right? Could you say, hey, that's not how he normally behaves, right?
Yes, that's
right?
how he normally behaves, but I wasn't.
Right. So with that being said, if that's not how he normally behaves, if that's not how he is interacting with you, you might want to believe Mr. Williams when he said, hey man, this man is kind of out of his mind, right? You might want to believe that, wouldn't you?
Yeah.
All right. And for purposes of this motion to revoke his probation, if he's out of his mind, he don't know the difference between right and wrong, then we might not, what's the?
Let him ask his question.
Yeah.
And then
Yeah.
you can,
Yeah.
let him ask his question and then you can raise your
Right.
objection.
Ask
your question.
I haven't asked the question.
Ask your question.
Let me ask
He
the
has a fair opportunity to object. Just complete your question.
All right. Again, you just said that you agreed with this Mr. Ham's witness that he appeared to be out of his mind, right? Now, my question to you is, a man who appears to be out of his mind and don't know right from wrong, we should revoke that man. We should keep him on probation and get him the treatment that he needs, not revoke him, right?
Objection.
Would you agree with that?
No.
Objection.
He had made legal objection. I'll just keep saying
Hold on,
objection.
hold on. I overruled the objection. He's answered.
All right.
Ask your next question.
I'll move on to another topic.
Thank you.
All right. So with that being said, that we could keep him on probation. If we were to keep him on probation, right? And we know about this incident of February, what services, since you are the mental health officer for what Mr. Ham asked you about as the mental health initiative caseload, what additional services could you provide for my client?
Could I provide?
Well, the probation department provide. I won't say I. What could Jefferson County Probation Department provide for him? I'll get him set up with.
For his mental health?
Yes.
Continuing spinal tap if he needs to go to a treatment facility for a prolonged period of time, we allow that.
Right. And at the end of the day, what's better for him, because you've quite sure heard Judge Stevens brag about the department. That we got a great Jefferson.
What's your question?
Well, here's the question I'm
You've
asking.
all heard.
Would you agree with me that the Jefferson County Probation Department works very well in meeting the needs of his clients?
Yes.
And in working very well to meet the needs of his clients, wouldn't you agree with me that you would be willing? The question is willing. I'm asking a question. Would you be willing and able to continue to work with my client? That is a question. Would you be willing and able to do so?
Yes.
Right. So since you would be willing and able to do so, your department is an exemplary department.
Yes.
Let's keep him on probation. How about that?
That's up to me.
Okay, got you. Now,
Did you hear his answer?
he said it's not up to me.
He's absolutely right, isn't he?
You
All right,
absolutely.
any other questions you
I
want
want
to
to
answer that don't have anything to do with his decision making?
No, Judge, I was gonna move on to.
Thank you. Let's go move
All
on.
right. So I dealt with 1 and 2. I dealt with 5. They abandoned. So let's move to 3 and 4 real quick. All right. On number 3 with the fail to report, I understand your answer is that he had pneumonia at that time, didn't
He had a host of illnesses, yes.
he? Pneumonia was one of them, right?
Yes.
COVID was another one, right? And then what was the other illnesses he had? So I just got a question, and I'm not trying to be funny, sarcastic, or anything like that. But Langston Adams has pneumonia. Langston Adams has COVID. Are you telling me you want Langston Adams to come to your office and report with you? Or you want Langston Adams to be within breathing distance of you?
No.
Okay, so for purposes of on the allegation, he failed to report. And I think Mr. Ham mentioned 2 days in January. Well, that'd be a good reason for my client not to report. If he has COVID and he has pneumonia, I don't think, the prosecutors want somebody, or you or anybody else want them in their office reporting with pneumonia and COVID, right?
But that's to a certain extent.
Okay.
COVID and pneumonia don't last forever.
I got it. They don't last forever. But again, you can testify under oath to Judge Stevens that a reason for him not reporting in January would have been COVID 1, pneumonia 2, and a host of whatever other issues that you said he had, right?
Correct.
All right. That's what I wanted.
Who diagnosed him with those? Did you receive some medical paperwork or something that verified? Since I don't think he's a medical physician. And you gotta, we trust, but we verify. What's the verification that showed that he had a medical problem?
He went to American Family Care Urgent Care.
Yes.
On 3195 Dowden Road. And this was on November 10th of 2025, where he was diagnosed with COVID.
Well, who says that?
The provider.
Okay, you have something in writing that verified that he had been diagnosed with an illness by
of a medical provider.
A medical provider? Okay. And you trust that's a valid document?
Yes.
Okay.
So basically, in answering Judge Stevens' questions, you did verify the pneumonia, the COVID, and whatever else that was wrong with him. And that would be a justified not to go report and got a contagious disease. All right. Let me move on to the.
Hold on. He didn't answer anything. You just asked him a question. He didn't answer.
Would you agree with that?
Again,
you answered it.
The date was for November 10th, 25. He didn't report in January 26th.
Okay, I got you. Let me move on to the next thing. That I'm looking at 5 real quick. I'm sorry. We
5 was abandoned.
5 was abandoned. I apologize. 4 is what I meant. He failed to provide verification performing community service hours, right? Do you recognize the lady to my right? I think that's his mother. Do you recognize her?
Just earlier.
Okay. On the failure to provide verification, right? Did you not make it absolutely clear that if he was working and he was working at KFC, didn't you make it clear that he would not have to do that community service while he was working? Didn't you make that clear to him?
I didn't make that clear. I said whenever he didn't work, he needed to come in.
Okay. How many hours was he working at KFC?
It depended.
What was his normal work schedule?
I'm not sure, but because he was at different KFC locations.
Okay. To your knowledge, has he completed any community service? Okay. And to your knowledge, with him working, did he have a pretty heavy workload?
No, I'm not sure.
Okay. And then the last thing is 6, the arrears of 2,738. I believe that's where Judge was at. I'm reading 2,738. that's when Judge was asking you about verifying his work, et cetera, et cetera. Remember that? Okay, so I guess my question as a part of that verification, do you know what his monthly expenses were?
No.
Do you know if he was in debt to anyone? Do you know in terms of our essentials as human beings? We need light, we need water, we need clothing, we need shelter, right? Do you know with that income whether or not he was able to meet those essential things that every human being needs to meet? Do you even know?
He was living in a nice house.
Okay. He said he lived in a nice house.
Pretty nice house.
Where was that? Whose home, is that his home?
I'm not sure if that's his home.
Or you don't?
Who home was it?
I'm not sure.
Okay. Do you know in this nice house? I got you. So basically, I guess you're saying that while your guy is on probation, you're supervising him, you didn't even know the name of the person whose house he was living in, right?
What was the address? Do you know?
Um, 2430 Guzman.
That's his mother's address, isn't it?
He said he didn't know.
No, I'm looking. That's his mother's address here in the court, in the papers. Right? You know? You don't know?
Who's saying no?
No.
That's not.
What's his mother? It says 2430 Guzman is his mother.
2430 is Ebony's house. I was staying with a girl I was dating. It's 2430 Guzman. Her address is 2438. It's
Next door. Is that next door?
No.
What's on? It's on down the same side of the street.
It's further up the block though. It's like her house is by a mailbox. Ebony is by the office in the front of the neighborhood.
He's saying he didn't. Okay. Well, I guess my point that I'm making to you is wherever he's staying, you didn't know who specifically he was staying with, right?
His girlfriend.
Well, he just said that. Now, so you saying the girlfriend?
I knew that.
Okay, and what was that?
And nobody else says otherwise.
Okay. In terms of meeting his expenses, do you know specifically why he could not pay that $2,735?
I don't know. A lot of our probationers have the money, but they decided to stay.
Well, we're not talking about the others. We talk about him. Well, let's say this.
Experience.
All right. You told Judge Stevens earlier, you said, I'm going to use your exact words. You said, hey, he has a lot of things going on. And Judge looked up. Well, we all got a lot of things going on. So I guess I'm going to follow up on that question by asking you, for him specifically, what are those a lot of things that he had going on for him?
No, he was dealing with his illnesses. He was working. And he said he had problems with his family.
Okay, so illnesses, he was working, he had problems with his family. Would you agree with me, and that's a question, would you agree with me that that's something we could use with Judge Stevens to mitigate this, to say, keep him on probation, don't violate him, look at all of those things, to use your language, that he was dealing with and working with while he was on probation? I'm using your, do you follow me?
I follow you, but I don't agree.
Okay. I thank you for your time. I appreciate you. And I think the state said for you to
family. What's the problems with the family else?
He wasn't always at his house.
I'm sorry?
He wasn't always at his mother's house. Sometimes they had disagreements from what I remember in our conversations. It was minuscule problems. It wasn't anything.
What was it about disagreements with his mother?
Yes.
What do you mean?
He would tell me they just didn't get along sometimes. And then he was staying with his girlfriend. It wasn't anything big in particular, but he said he just had a lot going on with family life.
Really? Well, that's odd. He's not supposed to have any contact with his mother. She's the victim of this crime that he assaulted her. That's why he's on probation. He assaulted that lady. He's not supposed to have any contact unless I approve it. He's been contacting? Dealing with? You're kidding me?
I haven't understand what
no.
He says, you've been associating with her. I'd allow it under circumstances, but she's the victim. You assaulted your mother. God bless you. Who does that on this planet? You're convicted of assaulting your own mother. And you can't have any contact with a victim. That's in your probation order unless I approve it. Shame on you. Anything else? It's just what happens in these hearings. I find out information that I probably should have been known about. Because I'm supervising. And apparently the rules don't apply, especially my order.
From my experience, Judge, just because they're on medication or just because they're off medication doesn't mean that they're less or more likely to commit a crime.
Thank you. I know that. I appreciate that. Thing is what I am concerned about is actions of free will that are contrary to the court orders. Go ahead.
I don't have any other questions. I don't have any additional questions.
Okay.
Needs to be excused.
Yes.
State rest.
Yo, we have a witness. We call Latrice Talley. Come on. And it's not gonna be long.
Well, that witness comes up. Lindsay, thank you for the $20 for overtime. I surely appreciate that. Thank you.
You solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Lower hand. Thank you. Be seated. Thank you.
Would you state, I'm sorry. Would you state your full name for the record?
Yeah, Tally.
And Miss Talley, what is your relation to my client, Mr. Hart?
Mother.
And you're his biological mother, is that right? And as far as the underlying case, which is, I believe, the injury to the elderly, as Judge mentioned that you were the victim complaint. Well, in that case, right?
Yes, sir.
And just to get this out, while my client has been on probation, has he done anything to you that you would consider to be out of ordinary, wrong? That has he did anything to make you uncomfortable, anything like that?
Not literally, no.
All right. And matter of fact, let me be specific and candid to the court. You reached out to me to come testify on his behalf. Is that right?
Yes.
Right.
That's right.
Right. I didn't solicit you. You solicited me, right? You came to Langston Adams. Langston Adams didn't come to you. Is that right?
That's right.
And with you coming to Langston Adams, you the one who wanted to come to Langston Adams' office to come speak for your son, right?
Right.
I didn't ask you to do that, did I?
No, you did not.
You did that on your own.
Yeah.
I'm sorry. What?
Okay. So
yes, you're leading.
Okay.
Go ahead.
Well, I just want to make sure. So with that being the
It's
case,
like, just tell the court in his own words what you know about this.
Okay.
These are your thoughts. He's helping you along, but I want to make sure that you know if he's not saying something that's accurate, you were there, he's not necessarily there, let me know.
Right.
It's clear. I need to know what the truth is.
Okay.
Notwithstanding the way the question might be asked.
All right, so let's get to these particular allegations, ma'am. You've been in the courtroom, right? You heard from the probation department, and you also heard from Mr. Williams, right?
Yes.
All right, and Mr. Williams described.
Judge, didn't Mr. Adams invoke the rule?
And we said no.
Not a witness to stay in the court?
Yeah, because you said no. You said
I had no other witnesses.
I understood that to mean that when I withdrew that request when he said that.
He did not withdraw.
I did. You heard he went in here, Judge.
For anybody, from both sides or either party.
When he made that statement, I backed
there's
off.
a good reason for it. That's so that people don't sit in there and listen to the testimony and then get educated on what they might be saying later.
Adams did not indicate.
She's going to I'm going to let her testify, but the problem you have is when they sit in the room and listen, that kind of takes a little of the sting and emphasis and the accuracy of what their statements are. And that's why we developed the rule of sequestration of witnesses is what it's legally called.
Well, let me ask you.
People are outside and they don't hear what other people are stating so that they don't get educated of other information that would add to what they already know, which is what they should be testifying to, just what's in their mind, not what other people are telling them who are testifying in the same.
But and I apologize, Judge, for the.
Go ahead and ask.
Okay, with that being said, let me ask you an opening question. You ask it any kind of way you want to, okay? Do you know if your son was receiving any kind of medications at the time of this alleged offense on February the 15th of 2026? You can tell me if you know or you don't know.
On his meds.
Why do you believe that? And you can answer it any way you want.
Because of his reactions. They were, I mean, he was all over the place, you know, his emotions. Because he wasn't on his meds.
Okay. Now,
hold on, let me get this clear. Was that his fault because he wasn't feeling good on his medication?
No.
Well, who told him to stop?
He hadn't stopped, Your Honor. He had ran out. So he was
Okay, so why didn't he go get it filled?
that has to do with the top.
Which one?
The place where he gets his meds.
All right. Okay.
The top.
All right.
They were supplying his meds. They are the reason why.
Well, why isn't he going to Spindletop to get his medication? Why wasn't he getting his medication? Spindletop wasn't refusing ordered medication by doctors. They don't do it that way. Why wasn't he going to Spindletop?
He had to wait for them, sir. Your Honor, my understanding is that when he ran out, he had to wait on them. Then
who told you that? Who told you he was having to wait on them?
I experienced.
Oh, you don't know for sure.
Well, I guess I don't.
You weren't present with him at the time.
No.
So you must have heard it from somebody else, I guess.
I heard it from my son because I was trying to.
Okay, your son was telling you.
Meds.
All right, go ahead.
Okay, so I remember I told you I was gonna be short, so let's get straight to the point of why you're here. All right. Did you hear Judge point out that you're the victim on this underlying offense of injury to the elderly, right? And you also understand that we're here for a motion to revoke your son's probation, right? You understand that. And you also understand, as Judge pointed out, he is the decision maker on this motion to revoke. You understand that, right? So here's the open-ended question I want to ask you, and I'm going to sit down, all right? Could you tell the judge, as the victim of the underlying offense, in your own words, look at him, why you want him to continue your son on probation? Why? And you can say whatever you want to that.
Objection is to relevance.
Sustained. But actually, I'll let her speak.
Okay. Tell him in your own words why you want him to remain on probation. Why?
Your Honor, my son needs intensive medical health treatment.
How do you know that?
This is not my field of expertise.
It's not, is it?
No, it's not. But I suffer from some of these same illnesses. So he's been through a lot. He's been sexually abused. He's been emotionally abused.
Were you present when that was happening?
I'm his mother.
No, I know you're his mother. Were you present when that was happening? Okay, you just heard that from others?
No. What happened?
How do you know that happened?
My perpetrator in the army stole him, his brother, and his sister from me. So yes, I know.
Well, how do you know what was happening when you weren't there?
I wasn't there, but I was there. I was not ever there. I was there indirectly because
indirectly
the perpetrator stole him and took him to Michigan.
Well, how do you know what happened when you weren't present?
Because the children were brainwashed. I wasn't
How do you
able to.
know they were brainwashed? You weren't
I was
there.
going to court, back and forth.
I know you were going to court, but you weren't present at the event, right?
But
You can't do it, so you weren't a witness.
when Your Honor, today, you're right, I wasn't present. So I'm speaking from me. I suffer with these illnesses. I have PTSD. My perpetrator is a result of the United States Army, okay? And my son has been, he needs intensive mental health because he's OD on fentanyl. And he lives.
Wait a second.
To tell about.
Where is he getting fentanyl from?
I'm just.
No, where did he get fentanyl from? That's an illegal drug. That'll kill you, much less brainwash you.
I'm telling you, Your Honor, my son OD'd on fentanyl, but he's here today.
God bless you.
I got a picture. I'd like to show you.
No,
my picture,
ma'am,
Your
ma'am,
Honor.
hold on. I don't disagree with you, but fentanyl, where is he getting fentanyl
I
from?
don't know where he got it
So you
from.
don't know a lot about your son then, do you?
Your Honor,
Do
what I
you?
do know is that my son needs intensive.
Fentanyl was not prescribed by the doctor,
Your Honor,
was it?
It was, he OD'd on fentanyl.
That wasn't prescribed by the doctor though, was it?
No.
No, it's not.
No, it's not.
He's getting it on the street somewhere.
Yeah, yes,
Right?
Your Honor, yes.
That's a crime.
There is a.
He's on my probation. He's not supposed to be getting fentanyl on
Your
the
Honor,
streets.
my point is, my son OD'd on.
The point is, he's committing crimes while he's on my probation.
But you know, he OD'd, Your Honor.
It was his choice to go find the fentanyl, right?
Yes, sir. But
God bless you. God bless you.
Your Honor, all I'm asking for is intensive mental health therapy for my son. That's
All I've ordered is for him to follow the rules and not commit crimes. And the more you speak, the more I learn he's not following the court's order.
You know, but this was in like 5 years ago, almost, when he OD'd.
I wish you'd have, I wish, he's been on probation for a long time here now.
You know, Your Honor, I'm just asking you if you would please consider.
He sees you regularly, doesn't? You and him see each other regularly, don't you? You see him regularly, don't you?
No, I don't see him regularly. He's homeless.
But I mean, when you see him from time to time.
Oh, yes. From time to time, I take him food.
I know.
I bring him food.
One of my court orders is he's not supposed to have any contact with you unless I approve it. I've never been asked to approve anything. I mean, every time you're saying something, it's a violation of his probation. I'm not sure you're helping him here.
Oh, I'm sorry about that. But when I bring him food, I bring it to his friends and leave it, you know.
Right.
That's what I do. So I bring him food, Your Honor. I'm sorry, but yes.
Well, that's a court order and, we don't want to be violating court orders. Okay. Oh, good.
But I do, Your Honor, want to ask you, please, consider, committing my son to, mental health, for, intensive therapy. I'm getting therapy right now, Your Honor.
For what?
For, PTSD or MST.
How long have you been getting treatment for that?
I restarted, but I've been in the mental health, realm for a long time.
Okay.
So, I just restarted my, mental treatment in March 24th.
Well.
And so,
you can't help but love your children. I know that. I've got children. But the children should not ever, ever, ever harm others, much less their parents. Their parents are special.
Yes, sir.
They should never harm their parents, and he was convicted of harming you.
Yes,
He's
sir.
on probation for harming you.
Yes, sir.
And the most important condition I had was to make sure that further bad things don't happen. And here we are. We're back, and I'm very proud that the probation office is because of it. We have a success rate. That's 13 out of 14. 13 out of 14 people are successful. He's here as a failure. And that's 1 out of 14. I want 100% success. But these are actions that I'm hearing about more criminal behavior and failures to follow the terms and conditions of probation, which the court ordered. That's why I hate failure. I want to see success all the time. And one of the problems is that you can help him with this, but the court order that we have in place is he's not supposed to have any contact with you. And I'm willing to change that, but nobody's asked me. And that means that people are changing the rules. And I'm the rule maker on probation, on my probationers. Y'all are going behind the scenes and doing things they shouldn't be doing. And here we are, I'm listening to them, and everybody's getting in trouble here. The more I hear, everybody's getting in trouble. It's one bad thing after another I'm listening to, and I haven't approved the behavior that's resulting in these acts I'm listening to. I mean, you got to follow the rules first. That's the way the law is. Those are laws. Next, I don't have any questions. Like, okay, thank you. Come on, man. Yeah. Next, that's it. That's my. All right. That's my only witness. Go ahead. Summary. Anybody? Want me to go? They can go first and last. Under the rules. They're passing. I'll pass. Go ahead,
Judge. What I'm asking you to do in this case is to continue him on supervision. So, for one overwhelming reason is he has documented mental illness, absolutely documented. And I confirmed that documentation with the probation officer himself, Mr. Ruiz, on the schizophrenia, the bipolar, the PTSD, the anxiety disorder. And even their witness, not my witness, their witness came up here and told you, hey, evidently, and I wrote it down, evidently he was out of his mind. He's not in his right mind. That's their witness saying that.
Who are not medical experts in that regard.
But their witness said that.
And has anybody ever told you you're not acting in your right mind?
Well, I mean,
but you're not going to say.
But I didn't do anything like this. But here's where I'm going with that, though, Judge.
By the way, Mr. Kimler, who is an expert witness in that regard, could have been called, but he was not called. But let's once again, what we're talking about are medical diagnoses, and
he has them from Splone type MHR. He's been diagnosed. They confirmed that.
Okay, keep going.
Right. The probation officer confirmed that he has those diagnoses and he was getting the 4 medications that he named. Mm-hmm. And Judge, what I'm saying is that just the offense themselves on the burglary of the habitation, their own witness said, I'm not saying he was burglarizing my house. That's a quote, direct quote from their witness. Word for word.
We're going to rely on what the elements of the offense are based upon the evidence as prescribed by the penal code.
Yes, sir.
It's a lay witness. He's going to testify, but we're going to rely on what was said, what's in the record,
yes, sir.
What the elements of the crime are as described by the penal code, not a layman.
Yes, sir.
But so he doesn't decide whether a crime is committed or not. It's going to be the law and the evidence that was presented, and that's what we rely on.
But Judge, I was just pointing out what you and I heard. We both heard the same thing when the man said, "It's not no burglary." I mean, you heard him say it. I heard him too, and I was just pointing that out. And then I also wanted to say, Judge, as far as on the indecent exposure, him doing what he did went more to his mental illness than to anything about sexual gratification or anything like that. My position is that if we were to believe the probation officer who had him for 18 months and this person said, hey, in 18 months, I hadn't seen this kind of behavior at all. If we to believe Mr. Williams, who knew him for 2 months and said, hey, I hadn't seen this kind of behavior at all. Obviously, on February the 15th of 2026, This was a guy suffering from a mental condition who did not know right from wrong at that time. And I'm attributing that mental condition of not knowing right from wrong to the behaviors that we saw in your probation officer. And I got it out of him in his testimony. His exact words is the Jefferson County Probation Department is equipped to continue him on probation and give him the treatment that he needs and continue him with the treatment that he needs. So I was going to ask that you keep him on probation, even if we were to take Mr. Ruiz's words for what they are. As far as on the violation of not reporting in January, I understand testimony to be is he had pneumonia and he had COVID. I got their witness to say, hey, I don't want somebody coming into my office with COVID either, and pneumonia and report having a contagious disease. As far as number 5 is concerned, verification, Judge, he provided his phone, and the phone showed that he did do the classes. I'm sorry. I'm going to the battering. Let me go back. As far as the community service is concerned, it's my understanding that because he was working and employed at KFC, my client wasn't able to do those community services hours because he was basically working. They abandoned number 5, and then when it goes to 6, that he was in arrears in 2000, having $2,735. I'll respond to that by using the state's witness again. Remember, you the one who brought up, Judge, and when the state witness said something to the effect that my client got a lot of things going on, and when we looked at his mental illness, what was going on with his family, what was going on with him at work, all those things contributed to him not being able to pay those fees. So, Judge, what I'm asking is that considering that the offer in this case was 10 years in the pen, and my client rejected that offer on the motion to revoke probation, I'm asking you to continue him on supervision. This is not a guy that needs incarceration. This is a guy who needs continued treatment, as your probation officer said. And most importantly, and here's where I'll sit down, Judge, the biggest person that's asking for you to keep him on probation is the very person who is the victim in this case, and that's his mom. His mom testified, and I asked her to tell you whatever she wanted to say. It wasn't no leading questions. It wasn't me suggesting the answer. I said, tell the judge whatever you want to tell him. And you heard her with your own ears that she wants her son to be continued on supervision. So I'm asking you, if you don't do it for my client personally, do it for the victim, which is his mother. His mother wants him to be continued on probation, and we're asking the court to honor at least her wishes, because you heard it with your own ears. You heard what she said. She wants her son to remain on probation, and I know the court heard her say that. So I'm asking the court just to honor what she wants, and she's the underlying victim in the case. And that's why I was asking for those things. I thank you, Judge, for your time.
Okay. Go ahead.
I'm going to stand by the evidence and ask that you find the accusations true.
All right. The evidence is before the court in this motion to revoke probation. It is alleged that the defendant committed the offense of burglary of a habitation on or about February 15th, 2026 in Jefferson County, Texas, in violation of condition 1 of the defendant's community supervision order. What does the state say about that? I'm going to go down each one. Okay.
As far as that is concerned, at the very bare minimum, he testified as to the lesser included offense of criminal trespass, Judge.
Oh, really?
He did. He said the man came into his house without his consent. He asked him to leave and he didn't do it. He had to forcibly remove him. That's the testimony that's before the court.
All right. Then let me cite to you State versus Meru, 414 Southwest 3rd, 2013, en banc Court of Criminal Appeals. criminal trespass is not a lesser included offense of burglary of a habitation. Why? They make it clear. The burglary of a habitation, breaking of entering is a different version of what it is defined as for criminal trespass. Burglary is committed if you partially enter into habitation. Criminal trespass requires full entry. That's why they said there is a difference. And it is not it's not been a lesser included since 2013.
All right, so as to the elements of burglary, person commits that offense if it's without the consent of the owner. We had the owner here, he said he entered his habitation.
Yep.
That's parent one enters the habitation. And he did that without his consent.
Yeah.
Let me stand by that, Judge.
Wait, hold on. And burglary, you didn't complete all the elements, and to commit a felony offense.
Look, I don't think there's no evidence of that, Judge. None. There was no evidence of that. And we also challenged the consent because he did say he opened the door.
Burglary, a person commits the offense if without the effective consent of the owner enters a habitation or building not been open to the public with intent to commit a felony or an assault or felony theft or assault. That doesn't apply. 2, remains concealed with intent to commit a felony theft or an assault in the building or habitation. That doesn't apply. 3, enters a building or habitation and commits or attempts to commit a felony theft or an assault. That's it. Where does that?
It doesn't, Judge.
Okay, so
I was relying upon criminal trespass.
okay, and criminal trespass is not a lesser included offense.
Yes, sir.
So burglary habitation allegation 1 was not proven.
And Judge, will we be to rely on the legal issues of res judicata or issue preclusion? Because if he's indicted and the court has made the finding, then we would be entitled to use that as a defense. If the state should try to indict him on burglary habitation, you have made a finding, and we would ask that finding so it can be used as an affirmative defense.
The court has made a finding that it was not proven by preponderance of the evidence or greater. It's up to a grand jury. If they want to indict, they will indict on what evidence is before them, which can be different from the evidence presented at this hearing. So no, you're not going to prevent a grand jury from doing lawfully their job. And that does not preclude the state from supplementing information in front of a grand jury that might be different from what was in another proceeding. So.
Thank you, Your Honor.
Number 2, committed the offense of indecent exposure. What do y'all say about that? State stands by it.
I stand by the evidence.
All right, anything from the?
I say it was not proven.
Okay, section 21.08 of the Texas Penal Code. Let's talk about the law. Describes what constitutes indecent exposure. A person commits an offense if he exposes his anus or any part of his genitals with intent to arouse or gratify the sexual desire of any person, and he is reckless about whether another is present who will be offended or alarmed by his act. An offense is under this section is a Class B misdemeanor, except that it is a Class A if it is shown on the trial of an offense, the defendant has previously been convicted of one time of such an offense, and it becomes a state jail felony if a defendant has previously been convicted 2 or more times.
And Judge, there was no witness who said that he did that for sexual gratification or the laws himself. As a matter of fact, it's just the opposite. The opposite is even from their own witness that they believe that he was out of his mind and not in it. So him exposing himself was due to him by their own witness being out of his mind, not exposing himself for purposes of arousal or sexual gratification.
Okay.
So I would say that they haven't proven that. Not one witness, not one, and you heard it all, said that he went in there for sexual
You've
gratification.
already said that several times.
So
Yeah. And
not one.
yeah, okay, yeah. Being an advocate, I disagree with you completely. I can draw reasonable inferences, and any jury is allowed to draw reasonable inferences from the facts. Somebody taking out his penis in somebody's house when he wasn't invited, and making masturbation movements. The court is going to infer that he was doing that to fit the element of attempting to arouse or gratify the sexual desire of the defendant. That is a crime. It's a misdemeanor. It is alleged in number 2 that he committed the offense of indecent exposure on or about February 15th, 2026 in Jefferson County, Texas, in violation of condition 1 of his probation order. I find that true beyond a reasonable doubt. Failed to report to the Jefferson County Probation Office for the month of January 26, and failed to provide verification of performing community service hours as required. Go ahead. What do you want to, anything to add on those last 2?
On those 2, Judge, Judge, you wouldn't want him to come report to you with those illnesses.
Once again, just make your argument. Don't bring me into the witness score.
The point I'm making, Judge, is based upon what their own witness said, and their witness even showed you the medical confirmation. He was legally and factually and physically unable to report for January due to having pneumonia. And
you've said that. You made it clear. I want to know what the state's position is.
That medical excuse that was offered was from November 10th.
Yeah.
These are from January of 2026.
But
that was like 2 months before. What about that? How do you explain that?
I explain it because what Ruiz testified was to January. I understand Mr. Ham's point when he's talking about the date of the excuse.
Yeah, isn't that important?
But the testimony was he had those illnesses in January.
Who said that? Who was testifying that? The defendant? Right?
No, that was Mr. Ruiz, the probation officer, because I had him on the stand.
Now, how was he diagnosing him?
No.
I know they have a lot of authority and they're smart people, but they didn't go to medical school. So how much weight are we giving to someone? What I want is a doctor's excuse. We don't have that. It's just statements being made by people who are non-medical experts.
The only thing I can say, Judge, is that Mr. Ruiz, the PO, believed in January that he suffered from those ailments. He believed that based upon his testimony.
To state, clarify that.
That is not what.
Yeah, I don't remember him saying that under oath.
When you asked him, he said the only medical information was predated.
Court finds that there is sufficient evidence supporting that allegation to grant it by a preponderance of the evidence or greater, as the court finds the defendant failed to report to the probation office for the month of January 2026 in violation of condition 4 of his probation order without a sufficient excuse. 4, failed to provide verification of performing community service hours as required.
Working at KFC is our response to that. That's why he couldn't do them.
Okay, state response.
Judge, he did 4 out of 600 hours. That in and of itself, in the time frame that was provided, tells me that he didn't work faithfully at doing community service hours.
How about that? Doesn't Hold on.
I'm sorry, Judge.
Doesn't the dramatic difference between the amount that he could have garnered for reporting versus the actual amount, which is minuscule over this vast period of time, which was he was on probation 2023 and just wanted to pray, and we're talking about through earlier this year, January. I mean, we're talking about community service hours for one half of 23, half a year for 6 months in 23, all 12 months in 24, 12 months 25, 24 and 6. That's 30 over 30 months, and he's only done 4 hours.
But Judge, in fairness to him,
I mean, doesn't the math just not work out?
right, but I was going to add to that math, though, you also got to consider, though, with him being on probation for 10 years, he still had seven more years to complete all of that. So I want to give him the benefit that he had an additional 7 more years that he would have had to complete. And if the court is willing to continue him on supervision, I have confidence he's going to get that done. Considering he got 7 more years.
All right. The court will find true allegations 2, 3, and 4 was proven by a preponderance of the evidence or greater. And in allegation 2, indecent exposure was proved beyond a reasonable doubt. And failing to report is number 3, failing to provide verification of performing community service hours as required. And the court finds that those are violations of this motion to revoke probation, and the court finds shortly to those. All right. And that is enough to grant the motion to revoke probation in this case. What do we do next?
Judge, I'm arguing that with him having that mental health condition and that with the probation department saying that they are willing and able to continue to treat him is to keep him on supervision. We did reject a 10-year offer, but we're asking to keep him on supervision.
What state?
Because of what the probation department said.
Okay, what state saying? What state are requesting?
I think it should be revoked, Judge. The behavior on February 15th, I get that legally it doesn't fit the Burger's habitation, but that we know it was trespass. We know that his conduct, as the witness says, was just not right. Every one of us would not want somebody to come plop down in our room. We ask them to leave, they don't leave, and then they pull their pants down and wag their penis at you. It's that conduct in and of itself needs to go to prison. And we add to that he was on probation and looking at his PSI, the amount of criminal history this man had. We gave him a break, giving him probation in the first place. I'm just a staunch believer that if you give somebody with a record that kind of an opportunity and they fail, then it's time to send them to prison.
Anything else by anybody?
That's it, Jeff.
All right, the court will find that there is sufficient evidence supporting this motion to revoke probation in cause number 22-40987, the state of Texas versus Courtland Julian Hardwick, to grant it by preponderance of the evidence or greater, as the defendant had pleaded guilty and was found guilty of the 3rd-degree felony of injury to an elderly person, namely his mother, in this case, and was sentenced to 10 years in prison, and that was suspended. He was placed on regular probation. Based upon these findings of the court that the defendant, it is proven true in this hearing that he committed the offense of indecent exposure on or about February 15th, 2026 in Jefferson County, Texas, which is a violation of condition 1 of his probation order. The court finds that not only by preponderance of the evidence or greater, but beyond a reasonable doubt, and that 3 and 4 of the allegations of violations in the motion to revoke probation, namely failing to report to the probation office as directed and failing to provide verification of performing community service hours as required, were proven true as violations by a preponderance of the evidence or greater. So thus, those were violations of his probation, 3 violations of probation of condition 1, condition 4, and condition 18 of his probation order have been proven true. This motion is hereby granted, and the defendant is hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. Let me just say one thing. There's been a lot of discussion about his mental health, yet nothing was presented in this court medically to show anything, a scintilla of evidence that he was incompetent or insane. Nothing has been shown. You're presumed otherwise. His actions are bizarre, but we see bizarre things all the time in this court that don't have anything to do to incompetency. Generally, it's drug usage or some other physiological issue, but generally incompetency is rare to be found, but it requires something other than lawyer arguments. And nothing was shown. And nothing was shown when we put him on probation. I made a finding that the defendant was competent to stand trial. There wasn't an issue on that. There wasn't anything presented otherwise. Sure, he has shown bizarre behavior, and he's being held accountable for bizarre behavior. But nothing shows in the record that the defendant was unable to conform his conduct to lawful behavior because of some medical reason. Thus, he is held accountable just like all of us. Shame on you for your actions, especially going in and committing a terrible offense of pulling your pants down and waving your penis to neighbors. Shame on you for that. We've had situations in this court where people pull out a gun and shoot the person in the head for that and shoot them somewhere else for good measure. But nonetheless, you're presumed sane and presumed competent unless otherwise shown. That means you have to follow the rules like all of us, sir. And you're going to be held accountable when you don't. That is all. We're in recess on this case. Next.
Alrighty, friends. Undoubtedly, we all have a lot of thoughts on this one and a lot to say, but we're already about 45-50 minutes into overtime, so now is not the moment. However, we did decide backstage while this was going on that this will be our topic of discussion for our next sidebar, which will be Tuesday, 8 p.m. Eastern, 5 p.m. Pacific. So if you have thoughts on this case, if you have more to say, join us for that. Again, next Tuesday, 8 p.m. Eastern, 5 p.m. Pacific, right here on this very channel. I hope you all had fun today. I did. Thank you, everybody, for your generosity, for your support. Lots of new friends today. I appreciate that. Lots of new members. And yeah, it was a good day. It's a good week. So I look forward to seeing you all on Monday, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you're a channel member. We will, of course, post videos throughout the weekend. This will probably be one of them, so look out for that. And good chance to refresh on this whole thing before Tuesday's sidebar. The wisdom I leave you with today comes from Abraham Lincoln. Discipline is choosing between what you want now and what you want most. I think those are good words, so do please ponder them as your weekend goes on. But in any case, go have a good weekend. Look forward to seeing you all soon. Take care. God bless.